this one. So.
Most important one.
How about I take yours out and put it over here?
I don't know if you. I know that could mess things up. Just yell.
Yeah, I'm gonna hate to do this. All right. Good morning. Hope everybody is well. We're gonna get started here. Will you get us started?
Let us pray. Dear Lord, thank you for being in the home stretch. Let us finish strong this race of the 2024 session. Thank you for the important business before us. Help us handle it with wisdom and full attention. In your name we pray, amen.
Thank you. All right. Hopefully those online can hear what I'm saying. Let's get started with Senate Bill 259.
Thank you, Mr. Chairman and members of the committee. I'm here to bring Senate Bill 259, which is one that it should be familiar to you guys at this point. There have been it's been before this committee several times, and Chairman Irwin has brought this bill, and it just took some time to make sure we got it right. Had a lot of local feedback. I appreciate y'all coming to the 50th Senate District in Banks County and holding a hearing in the off season. But what this bill does is it moves Banks County from the Piedmont Judicial Circuit, which is currently comprised of Jackson, Barrow, and Banks, and puts it in the Mountain Judicial Circuit, which is comprised of Habersham, Stevens, and Rabun. I'm happy to answer any questions if there are any.
The reason it has returned back to us, I think this is the third time, is that right? Or fourth, was the date, the effective date. What is the effective date currently?
The effective date
bill?
in the substitute that you have before you is January 1, 2025.
Okay, it gets us past the election and should take care of those issues.
Yes, Mr. Chairman.
Right, all right. I have a question on who's got 13 over there? Chairman Smith.
Appropriate time, Mr. Chairman.
All right. This will be the time.
Move to pass.
All right, got a motion and a second. All those in favor say aye.
Aye.
Any opposed? All right, you're done.
Thank you very much. Chairman Irwin will be carrying.
Yep, yes, thank you. All right, let's call Senate Bill 414.
Good morning, Mr. Chairman
Good morning.
and committee. Nice to be with y'all again.
All right,
Ready?
yes, go ahead.
Okay, thank you. Good morning again. So I think we all know this, but to state the obvious, charities play a very important role in our society. And this bill seeks to protect donor information from unnecessary government collection of donor information and disclosure of that information. Donors contribute to causes that they believe in and that they believe they should be able to do so, as I think most of us do, without the fear of governmental interference. The Constitution protects the freedom of association. That's the 14th Amendment also protects the freedom of association as a fundamental aspect of liberty, and also First Amendment free speech. Government attempts at intimidating civic and advocacy organizations through forced disclosures of donors and member information goes back generations, and it was the subject of a 1958 landmark decision in the NAACP versus Alabama. This bill protects nonprofit organizations from having to disclose personal information of its members and donors to public agencies, except in very limited circumstances, and there are 3 of those circumstances set forth in the bill. One would be what we would expect is during discovery, where that would be needed. Second would be pursuant to a lawful warrant, which of course that information should then be provided. And third, when engaging in contractual obligations with the state. Sometimes that also requires the disclosure of information about the charitable organization. When personal information is properly disclosed to public agencies, the bill protects it from public disclosure by penalizing the unlawful release of that information. This bill does not affect the required disclosures related to campaign organizations or registration as an entity doing business in the state, nor is it protected from the current processes that state agencies have to do in their normal work of regulating and also licensing non-charitable businesses such as nonprofit banks. There's some teeth to this to make it enforceable, which of course we would expect. Penalties begin at line 101 with the declaration with declaratory and injunctive relief being available. And the civil action is also made available where an injured party can be awarded up to $10,000 or triple that amount if there is a willful violation of the statute. An employee caught violating this bill can also be subject to a criminal penalty as a misdemeanor. Mr. Chairman, that's sort of the thrust of the bill, but I'd like to, because I know we're operating from a sub, so if I may, I'll point out the differences from what came out of the Senate. It's pretty brief.
Yeah, that'd be fine.
Yes, sir. Beginning, and I'm looking at LC 560189S, as in Sierra. Is that the right one, Mr.
That's the
Chairman?
one we have, yes, sir.
Okay. Added to what we passed out of the Senate begins at lines 84 and goes through lines 95, which is subparagraph 12, A, B, C, and D. And these were added as a product, really, of, I want to thank James Bill, my counsel to my office, who worked with some of the governmental agencies who came forth and said, wait a minute, there's some times that we contract with vendors who are nonprofits, and the requirements on us as a state agency, we need to know about the membership to make sure that if we're serving a vulnerable population, that we're properly vetting those people that are going to interface with the people that they serve. And so after a lot of conversations and work that James did, we've added, or as seen in this sub lines 84 through 95, and as you'll see, DHS is accommodated, DBHDD is accommodated, and DCH and maybe some others, and Department of Juvenile Justice. Mr. Chairman, that's in essence what the bill does. I'm happy to answer any questions.
All right, any questions by the committee? Representative Holcomb.
Yeah, good morning, Senator.
Good morning.
Can you explain lines 97 through 101, the part about exempting securities issues with the Secretary of State? What specifically is that doing?
I may need, with your permission, Mr. Chairman, I know the Secretary of State's office is here. I know they're in support of the bill. Would it be okay with you if I asked them to? Neela, can you help, or James? Was that 96?
97 through
97.
101.
You have the sub 97.
Yes.
Yeah.
So in our registration filings, charitable organizations have to register with the Charities Division in order to accept donations or solicit actually from donors. And in those filings, we have different required documents, one being the IRS Form 990. The IRS Form 990 has a schedule on it that lists donors who give donor and their information, but donors that give over $5,000. And we are very much in support of protecting that information, and that's why we're in support of this.
Okay. If I heard you correctly, that applies to the charitable organization side of the SOS. This applies to the security side.
Yes.
So
and
how does this relate to the security side?
So in some instances, some of those charitable organizations may make securities filings as they're maybe accepting capital. They could be on the exchange, and that's, you know, they have foundations that are on the exchange, and they have filings with us, and they may, you know, submit certain filings that might have donor information. We haven't seen it yet come in, but that could be the reason that's there.
Okay. All right. Thanks. I'm a securities lawyer. That's why I want to make sure that I understand what we're doing here.
Okay.
All right,
Thank you
thanks.
for that question and helping us make sure it's. Yeah. Is that
Oh,
mine?
yeah, that's yours.
Yeah.
Representative Oliver, is that you?
Good morning, Senator.
Good morning.
similar is this to the bill that we discussed before at length that was brought by Matt Reeves? I can't do all the checking myself.
I think it's substantially similar, probably with the exception of what I pointed out that's different as what we passed out of the Senate and what's being offered today as the sub.
We had a good discussion. I'm trying to remember all of it, and many of the questions that are being asked is about the revealing the identity of people making campaign contributions to a variety of different kinds of PACs. And the reality is I'm not an expert on the evolving law about these PACs. We pass something every year, and the litigation is pretty active in that area. I assume you're an expert on that, so tell me how this overlaps with the identity of people making contribution to political PACs.
Sure. First of all, for the record, I'm not an expert on what you talked about. But the good thing is the way this bill is written, I don't have to be and y'all don't have to be, and really none of us have to be. I would direct your attention to line 46 of the bill. Subsection D says subsections B and C of this code section shall not apply to, number one, any report or disclosure required by Chapter 5 of Title 21. This is our complete and total election code. So anything touching on the subject matter you just mentioned is excluded from this by that line.
And there are going to be creative lawyers out there that are creating new PACs that are going to make some exception argument to this. Yes or no? Are you worried about that?
If they're making arguments, you're talking about lawyers making arguments or legislators? What do you mean? I'm sorry, I don't
I'm talking about the
understand.
next stage of personal identity of major, whether it's David Geffen in California or Bernie Marcus in Atlanta. I understand that they don't want their name giving $5 million to a candidate. I understand that. I'm just nervous that this overlaps with the law that we want campaign contributions to be public, identified.
Okay, I think I understand the question. I don't think there is I appreciate the question. I don't think there's the concern in the vein in which you have described it because, and I'm not an expert, but as I understand, 501c3s are charitable, nonprofit, tax-exempt corporations in which they cannot involve themselves in political activities, right? So that wouldn't be an issue, and that's whom we're mainly that's who we're trying to protect. 501c4s
Right.
who can get political,
Right.
but then there are the disclosure requirements that attach to them. Nothing about this bill or the process or the policy behind it impairs that at all.
That's the general consensus, but I continue to be nervous about creating secrecy of major donations that are going to overlap with politics at some point.
Again, Representative, I appreciate the question. I appreciate the concern as well. I don't know how we make this more strong or word this more strongly than to say anything in Chapter 5, Title 21 is exempt. I don't know how more broad we can make it. Thank you. Yes, ma'am. Thank you.
Chairman Smith?
Thank you, Mr. Chairman. Mr. Pro Tem, good to see you again.
Yes, sir.
Been
You
too
too.
long since yesterday
Thank
evening. Good thing is we hold committee meetings early in the day for Judiciary over in the House. So maybe y'all take a hint over there.
I kind of like your schedule better than ours. I really do.
I understand. Real quick, question on lines 107 to 109. I understand we all try to get the perfect working on what the damages amount will be for folks, but just wondered, is that enough to cover this sort of conduct?
I hope it is, but obviously trying to put teeth in it and make it effective, I would be open to the collective wisdom of this committee if y'all think it needs to be stronger. I certainly wouldn't object to that, and I don't think those we've been working with would oppose it either. Would you? Okay.
There are also a criminal penalty in there for employees who engage in that activity.
I think part of the thing. Yeah.
Sorry, Chairman.
Online.
Just want to note, in addition to the civil action that's in there, there's also a criminal penalty for employees.
Right. Well, if I add all that up and with the language there, I mean, that could just be the cost of doing business. That's why I suggest that, and I'm glad that you would be amenable to it, because I trying to figure out that dollar amount there, and I'm thinking, well, you know, I could do this and just consider it cost of doing business, you know, fine me, lock up whoever you want to, and that's just the cost of business for the day there. So that's just kind of why I bring it to your attention.
Mr. President Pro Tem, on that $10,000 amount on line 108, was that one perhaps the only difference in the House and Senate version? I think we had some feedback from some members here in the House who didn't want to have the limitation on that. Just throw the book at anybody who violates this was kind of the House approach to it.
Yes, sir. I don't have an objection to that. Mr. Chairman, if James was about to say something, it may address Representative your point as well.
James Beal, counsel for the Pro Tem. I apologize for that, Representative. Yeah, and just to note, this is targeted at bad government actors. So ultimately, the penalty would apply to a government actor. Just wanted to note that.
Okay. Who's got 16 down there?
Thank you, Mr. Chairman. Good morning,
Good morning.
Mr. Pro Tem. How are you?
I'm well. I hope you are.
Just to address Chairman Smith's concern, as I interpret the language, the $10,000 limit applies to actual damage, but there is a provision that would allow for treble damages if the violation was willful. So you would get your actuals up to $10,000 plus treble if it's willful plus attorney's fees. So is that the way you would interpret that?
It is, Chairman, and thank you for putting that clarification on it. I think that does more fully encompass what one would be subject to. Yes, sir. Thank you.
So I appreciate Chairman Smith's concern, and it may not address it, but if you've got an intentional violation, you potentially could recover more than $10,000 if that maybe addresses the concern to some extent. Thank you.
Yes, sir. Thank you.
Representative Kelly.
I guess I'm trying to wrap my head around it. And I guess my question would be, what are the damages that we would anticipate? Like, are we talking about damage to a reputation? And if we're talking about if it's a business or a big individual, an individual who suffers damage to their reputation, 10,000 is not a drop in the bucket. Neither is 30, and that's what I'm trying to wrap my head around. And maybe I'm misinterpreting what the actual damages would look like for someone who has their donor history out into the public sphere without wanting to. So help me understand what kind of damages we're trying to protect them from.
Representative Kelly, I think that's a good question. I think you are sort of from a trial counsel's standpoint unpacking how this would unfold from a litigation standpoint and in a court setting. And I think it is a little hard to project what those damages and the elements of those damages, what they would look like without having some context of the organization that suffered the breach, suffered the wrong, what that membership looks like, what were the circumstances, how broadly was it cast, what were the ramifications and ripple effects of the improper disclosure, and how did that impact someone. I got to tell you that I could go down that road, but I would just be giving you hypotheticals of how it might go. But as you know, it is from which the actual damages would be determined. So I don't know that I've got much of a better answer for you other than things that would touch upon those type points that I just raised. So I think it is a little bit of a struggle to do that. But at the end of the day, for civil remedies, it's other than you get general, specific, and punitive. So at some point, it's got to be tied to the actual damages. But I'm open to making this better, certainly making it stronger, making it and more clear. You may have some good ideas on that.
I just always worry about caps. And one reason is I'm thinking about the restaurant owner who has a successful small business that's generating revenue of $200,000 a year that he lives and feeds his family off of. he makes a disclosure to an organization that someone doesn't like, and all of a sudden the protests start piling up around his restaurant to the point where he's not able to open. And eventually, you know, a couple weeks of a restaurant not being open, it can put him out of business. And now he's lost a multi-year generating $200,000 business. And that's where I worry about putting a cap in general, and maybe we ought to just leave it to the trier of fact, maybe to determine what that individual's business is instead of putting a cap on. Would you be open to something like that?
I think so. If I could answer it this way, this may help us all, Mr. Chairman. Megan Schmidt is here. She is with the Philanthropy Roundtable, and she might have some specific examples of how she has either seen this or would anticipate this. Would you like to hear from her, perhaps?
Thank you,
On
Mr.
that
President.
point. Thank you,
Okay.
Representative.
Hold on. Just hold just a second. I'll come back to you.
All right. So on the cap issue, I don't think we've got an issue raising the cap or not having no cap, if that's the preference of the committee. I think a lot of when you talk about fees, whether it's civil or criminal, we're talking about deterrence. The goal is deterrence, right? To keep folks from disclosing the information to begin with. But we're happy to have that further conversation if we need to do some changes around those fees.
Let me ask you to tap that right quick and see if it's working. There, okay, all right. Wanna
Sorry,
make
I'll
sure.
lean in closer.
Yes, sir. Come back to Representative Evans.
Thank you, Mr. Chairman. Thank you, Senator. My question is on lines 110 to 111, where it says nothing in paragraph 1, or nothing in paragraph 1 of this subsection shall be construed to constitute a waiver of sovereign immunity. And since the discussion of damages is written in the passive voice that a successful claimant shall be awarded on line 107, I worry that those two things are going to keep you from getting damages, because you're basically not saying where the damages are going to come from, because you're doing it in passive voice, and then you're saying we're not waiving sovereign immunity. So I'm wondering if, first of all, do you agree with me? And then if you do, I think you could fix that by just adding to the end of line 111, and I want to know if you're okay with this. Nothing in the paragraph shall be construed to constitute a waiver of sovereign immunity beyond subsection 1, or something like that, to make it clear that that is allowed.
I think that's a good catch.
Okay.
So thank you for that. I do see where that is an internal inconsistency. So
Okay.
Representative, thank you for that.
Sure.
Ma'am, do you have any?
No, I think that's a good solution.
Vice Chair.
Thank you, Ms. Schmidt. You've got this bill and then the donor intent bill that Chairman Cowsert's bringing. Tell us about the good work that Philanthropy Roundtable does.
We are an organization, so we have our policy arm, if you will, that advances policies for donor privacy, donor intent. We're really about protecting donors in the charitable space, making it less burdensome for organizations to do the good work that they all do nationwide. And then the other thing that our organization does is we focus on the program side. So we recommend people, or organizations, I should say, for folks to donate to. We like to highlight and spotlight all the good work that's going on around the country. Thank you.
Representative Bruce.
Kind of along the line, just in a different vein. Can you give me an example of an actual damage that would be caused if somebody leaked this information or put out who the donor was? I mean, what is the actual damage?
It's going to be up to the courts. I don't know off the top of my head if we have any examples of where this has actually went to damages. You know, you have AFP v. Bonta, but I don't recall there being a damage in that case. I think it was just they ruled against the California AG and kind of set that precedent for not being able to leak those names or disclose those donors.
So if there's no example of damages, to your point, if there's no example of it, then what are we doing this for? Why are we doing this?
So we're trying to codify the AFP v. Bonta decision. And while it's law federally, states still need to have that codified. And like I said, the damages specifically, it's just to put teeth in the bill to discourage against that disclosure.
Okay, I guess what I'm trying to do is find out what it is that we're trying to protect. You know, because to Mary Margaret's point earlier, I'm concerned that if we're not trying to protect anything, if we don't have any examples of what we're trying to protect, I'm trying to figure out why we're even doing this legislation. But if it is that there is some damage that can be caused, if you give me, you know, $1 million and somebody else finds out that you gave me $1 million, what is the damage that has been, what's the damage as a result of that being out there? Sure. You gave me the $1 million, so it's a fact. So what, I'm trying to figure out what what are we trying to do with this bill? I don't get it. You know, and my concern, if we're not trying to, you know, fix something that's broken, then what are we creating? What are we doing? Are we giving somebody a legal way to hide what they're doing with the money, you know, that's being donated? I'm just not getting it.
Yeah, not at all. Thanks for the question. And let me answer this a different way. So we have cases of individuals being harassed nationwide, being intimidated. You know, this is really about protecting that small nonprofit donor. We're not talking about the millionaires and billionaires. We're talking about your everyday person who donates to these nonprofits who, for various reasons, they don't want their identity disclosed. And I think, you know, it's not just donors. We're talking about protecting the members, the volunteers as well. And so in today's climate, you know, there's various reasons people do not want that information disclosed, whether they are the volunteer or the donor. And so what this bill is doing is it's protecting those people, and it's giving them the courage to still donate or participate in a nonprofit that they may care about without having to worry about their information being disclosed. That's what the core of this bill does.
Okay, I won't belabor it, but I'm still, you know, if I believe in a cause, if I believe in something and I want to donate my money to it, I donate it, and I don't try to hide it. I mean, I feel like it's a worthy cause, so I'm going to fight for that cause. But I just still, I'm uncomfortable because it feels like we're trying to give somebody or some entities or whatever a legal way to hide something that they shouldn't be doing. So, but anyway, that's my feeling.
Mr. Chairman, may I address that? Representative, thank you for the comments and sort of giving us some insight to your thoughts on that. I can assure you that is not what this is about. That is not what this bill does. It in no way encourages that, in no way furthers that. What it does do is speak to a policy issue, and that is that our state agencies, governmental actors, ought not to inappropriately utilize information related to an entity, for in this example, a charitable organization, to force information out to then bring disdain or disfavor or harm to that organization. The case that I mentioned in my opening comments, it kind of is a seminal case in which to begin this line of thought and for the protection that's needed is the 1958 case of the NAACP versus Alabama, where the state was forcing the NAACP to reveal their membership list. Why? For inappropriate reasons. Absolutely reprehensible, inappropriate reasons. And so the policy that needs to be furthered is the state ought not to do that. This is completely aligned with that, consistent with that. And then to your question, which is a good question, and we've struggled a little bit with the damages issue, is we can say, we can put in the law that state agencies won't release this information. But if we end there and don't go further, what's to ensure as best we can within the parameters of reasonableness that that behavior that we've said don't do, state agency, doesn't happen? And that's where we've overlaid with some teeth in this and the penalty.
Mr. Chairman, just real to respond. I understand that there's a difference between a donor list and a membership list. Those are two different things. And this, which the example you gave about the NAACP and the membership, I agree. You know, my membership, you know, in an organization could very well cause some problems. I've had that experience here at this Capitol. But we're still talking about two different things. You're talking about a membership list, and I'm talking about a donation to an organization. But again, I don't want to belabor it, but I'm trying to figure out exactly what we're trying to protect, and she is telling me that she can't come up with what we're trying to protect. So that's why I'm asking the question. I'll leave it alone.
All right. Representative Kelly.
Mr. President, maybe you could help me. There's two ways you can be active in an organization or contribute to an organization. There's with your treasure, your resources, or with your time and your efforts. And so we talked about maybe individuals who don't have money to donate, but maybe want to help with a voter registration in disadvantaged communities. This would offer them protection against the small business owner who wants to dedicate just their time, maybe not their resources, but their time, helping a voter registration in a disadvantaged community without fear of their business or their car wash or restaurant, their laundromat from being targeted and harassed because they want to help register voters in disadvantaged communities. Do you think this would help those individuals?
It absolutely would. Representative, thank you for putting it in that context. And the one thing I wanted to clarify, and I have maybe not done a good job messaging to the representative's questions, it's not just donor list, it's membership as well. It's volunteers, it's activity with the organization, it's connection and connectivity with the organization. So it's not just a donor list, it's not just campaign contributions, it is all that Representative Kelly, you put very aptly in sort of real world terms. Thank you.
Okay. Representative Holcomb.
Thank you, Mr. Chairman. I appreciate this discussion. I want to ask it from a different angle, which is most of the nonprofits that I've ever donated to, they list the donors, and most people want to be listed. Like, they want that acknowledgement and everything else, particularly like the high donors and everything. They usually do it by class at certain levels and everything. Is there anything in here that would get sideways with that for those that want to do that? I understand that you're trying to protect those that want to be anonymous and don't want to have their names included. Does this in any way, would it impact organizations continuing to publish their donors if they so chose? And then do they have, and I don't know this area, do they have obligations to give their annual reports that list all that data to any of our state agencies? So that would then need to be redacted as a practical aspect. Like, can you address that?
Yeah. So for the first part of your question, no, if an organization still wants to list their donors, this bill doesn't stop that. And it's on the donors to know that those organizations do list them. And to your second question, yes, there's reports. So you have the 990 that gets filed with the Schedule B that is the donor information. It's redacted. So theoretically, that information can't be public, but there's nothing to say that that information cannot be put on the organization's website if they so choose.
Who redacts it? The organization or the agency pursuant to this bill if this were to pass?
It would be the agency that redacts so like, for example, if you get an open records request, that 990 is redacted.
Okay. All right. I understand. Thank you.
And Chairman Leverett?
Yes. Thank you, Mr. Chairman. To clarify a point that I think has been made earlier when Representative Reeves presented the similar bill in Government Affairs, as I understand this bill, it prohibits disclosure of this information by a public agency, not necessarily by the institution or the charity itself. Is that correct?
That's my understanding. Yes, sir.
Right. So if I would agree that it doesn't really seem reasonable for me to insist that an agency not disclose my information, that a charity not disclose my contribution if that's their policy to do so. I shouldn't be able to dictate that policy. I think what the bill is trying to do is make sure that a government agency that gathers that information in the course of its functions doesn't then disseminate that information out to the public.
That's exactly right.
Okay.
Yes, sir.
And my further understanding was part of the reason for this, to address the question of, well, why are we codifying something that's a Supreme Court case, is apparently some states aren't aware of that case or haven't figured it out or choose to ignore the case. And the idea here is to place it in code, which would be more accessible to that agency, so they would be aware, not only is it a matter of federal policy, but it's a matter of state policy, and they would just realize that they're not to disclose that kind of thing.
Absolutely. Stated better than I did.
Well, I don't know about that,
No, I
Mr. Pro
did.
Tem, but
Yes, sir.
I just want to try to make sure I understand. And thirdly, a statement was made about the witness not being able to state what interests she was trying to protect. I think she's articulated the interest that the bill seeks to protect. It's personal privacy. Admittedly, I think we're having a hard time articulating is, well, exactly what would damages for a violation of this look like? And I think that is difficult to anticipate because we don't really know the situation in which the disclosure would happen. We don't know anything about the person whose private information is disclosed. We don't know anything about the interest, their particular interest they may have sought to protect. So it is admittedly difficult to specify, well, this is a kind of damage, but I think Representative Kelly did so. And I think the idea here is, just because we can't figure out every way this could be damaging to someone doesn't mean we shouldn't provide some kind of penalty for the disclosure of that information. And it would seem to me that I know there's some concern about the cap, but since we are talking about recovering damages against a public agency, it would make some sense to limit that to something that's reasonable, so we don't potentially subject ourselves to, undue liability there. So it seems to me this threads the needle reasonably. And I just, to the extent you want to comment on that, I suppose that's more of a comment than it is a question.
Well, thank you for that. And I do, and I think bringing the focus back to who would be the subject of potential penalties, I think that does make a good point, that we don't want that to be unlimited. And this may be one of those things that we, over time, if we in fact learn that, or future legislators learn that this is not enough, that for some reason a state agency is ignoring fines, which is a little bit difficult to conceive of that happening. But if that's the case, we can always strengthen it. But I think this is probably a balanced approach, given from where we are now going to where we're trying to get at the moment.
And I would assume, Mr. Chairman, one other comment. I would assume to the notion of the sort of a rule that we will apply to the private charity. If I don't like my information being disclosed, I think most charities tell you that. My remedy is just not to make the contribution, and the charity makes that call about what their policy is.
Exactly. Yes, sir.
Thank you, Mr. Chairman.
Representative Silcox.
Thank you, Mr. Chairman. I guess I was going to bring up another possible example, and I think this is an important policy because I think it's important that the state remain neutral. Some nonprofits are associated with certain parts of the political spectrum, and so I think to the degree that people could be associated with identity politics in certain cases, I think that this would be a problem, and I think it's, again, important that the state remain neutral, so I think it's a great bill.
Thank you for that.
All right, I don't see any more questions. We've got a few people that want to speak on this, and Ms. Schmidt, you're here, so
Yeah.
would you like to go forward?
Oh, I can, sure. All right. Well, thank you, President Pro Tem, for sponsoring this. Chairman Reeves, really appreciate it. So I talked a little bit about the roundtable already, but just so you guys have the full picture, we're just a community of donors. We have members nationwide that consist of community, family, and private foundations, along with some individual donors, but the bulk of our membership are foundations. And I think part of the reason we wanted to bring this forward is we really wanted to protect nonprofits and their privacy. it is critical that nonprofits continue to have donors in their orbit, and I think a bill like this really gives that confidence to these donors that their privacy will be protected and so forth. So I'm happy to answer any additional questions, but I think President Pro Tem did a great job with introducing the bill and so forth. Thank you.
I see no questions.
All right,
Thank you.
Thank you.
Ann Gray Herring.
Mr. Chairman, do you want me to stay here or wait?
You're good for
Okay.
now.
Okay.
If they have a group that wants to come up, I
All
may
right.
ask you to move.
Okay.
Introduce yourself and
Yeah, sure. My name is Ann Gray Herring, and I'm with Common Cause Georgia. We do a lot of general pro-democracy work and government transparency work. And I just want to speak briefly to some of the concerns already raised about the, political campaign contribution overlap with this. We fully can get behind the interest in protecting the privacy of donors to charitable organizations, but that interest must be weighed differently when we're talking about organizations engaged in electioneering activities. I do understand that, in lines, I think it's 47 through 48, that the code section shall not apply to reports or disclosures required by Chapter 5, Title 21. But I think there might still be the type of spending that we want to be disclosed. It's not necessarily covered by that code section. That covers donations to actual campaigns. It covers filed lobbyist report filings and things of that nature. But, there's a lot of types of political spending. I think we see ways to circumvent campaign finance, the way that donations can be used to influence the political process that might not be covered there. Our best suggestion for this is to just say that this code section applies to 501c3s but not 501c4s, just given the reality of the type of activity those organizations tend to be involved in, and just considering this in the backdrop of the court's reasoning in Citizens United. Obviously that changed a lot about the campaign contribution landscape and opened the door for unlimited amounts, but even in that decision, the court reasoned that, the reason why these unlimited amounts were okay was this unlimited spending by donors would not distort the political process because the public would be able to see who was paying for campaign ads and give proper weight to different speakers and messages. And if donors are, able to donate and their spending is to these ads, that disclosure piece should be there. Thank you.
I have a question.
Yeah.
Representative Silcox.
It's actually me. I'm borrowing the microphone. Is
right.
Common Cause a 501c3 or C4?
We have a 501c3 and 4 arm of the organization.
Okay.
It's, there's the Common Cause Education Fund and Common Cause.
All right. And you've got federal and state campaign contribution disclosure and other requirements that currently exist, right?
Right.
And this bill does not abrogate those whatsoever, right?
Right.
All right. And are you comfortable, before this bill is enacted, having state and local government in Georgia having the ability to gather your your donor list and volunteer list?
It's my understanding that this bill wouldn't allow them to get the volunteer list, just the donor list.
No, lines
Okay.
lines 28, 29, and 30 say that personal information is a list of members, supporters, volunteers, donors, financial or non-financial support of a nonprofit organization. Are you comfortable, prior to this bill being presented by President Pro Tem Kennedy, that some government official at the state or local level in Georgia could go gather Common Cause's donor and supporter list? Are you comfortable with that? This would provide your organization protection from a government official gathering your list.
I think definitely the way you have to think about membership list is a little different than donors. But I do think there's, and for so many charitable organizations, I absolutely agree with what this bill is doing in protecting their privacy. But I do think there is a line for organizations whose activity is political and they're engaged in electioneering activity. And in that case, in any situation, you have to balance interest, and that the interest might weigh more in favor of transparency for who's engaged in these political activities, who's contributing money that is able to influence them, more than the privacy of the individual donors there.
Okay. Representative Oliver.
My question is for the senator sponsor. Do you believe that C4s are not covered by paragraph C, 45 and 46? And I wonder if you would object to specificity that 5013s are not covered by this bill, excluded.
I'm sorry, Representative, which lines are you?
I'm looking at the 45 and 46. We're saying that it doesn't apply to any election law, but does it cover 501(3)(4)s or not? I don't know the answer to that question. I really don't.
Would you mind if I ask James assist with this?
So again, James Beal with the Senator's office. Sorry. So if you go to A1 under line 16, nonprofit organization means an entity that is exempt from federal income tax under 501c of the IRC. So it covers the full spectrum of the 501c. 4, 3, 6, so on. Yes, ma'am.
So we don't need the amendment, is what you're saying?
It's not for me to say.
Thank you.
There's no need. It covers all of them. Yes,
Thank you.
ma'am. Yes, ma'am.
Okay. Vice Chair Reeves.
President Pro Tem, isn't it true that social welfare organizations, as defined by the IRS, 501c4s include Rotary clubs, Kiwanis, homeless organizations, immigration organizations, many other social welfare organizations that do good work here in Georgia in all 159 counties?
You're absolutely right, Representative. Thank you for that. Yes, sir.
Okay. All right. Let's see. Ms. Herring, do you have anything else you want to say? Thank you. Who's next? Okay. Alex?
I'll waive my testimony.
You waive? Okay.
I've written testimony.
All right. Thank you. That brings me to Jacqueline Harn. You would state who you represent and then give us your statement.
Good morning, everyone. Thank you for having me. My name is Jacqueline Harn, and I am with Americans for Prosperity, and I'm the Coalition's Director. I will be brief because in each of your folders you should have a description of most of this written testimony that goes into further detail about the court cases that I previously mentioned as well. But AFP is no stranger to the danger of a government that looks to squash speech and intimidate donors. In 2021, the Supreme Court ruled in AFPF, so Americans for Prosperity Foundation, v. Bonta, that the California Attorney General's sweeping demand for nonprofit donor lists violated the First Amendment. I believe the initial request was in 2014 for a lot of this information, and over those 7 years until the ruling was officially announced, there were home addresses, personal information that were actually listed on government websites. So the court found that California could not demand lists of an organization's supporters just because it wanted it. It also found that disclosure laws open up individuals to risk, harassment, economic retaliation, and more, basically, and issues that chill free speech. By striking down the California mandate, the court reaffirmed that Americans have a First Amendment right to privately support the causes of their choice. In this court case, nonprofits across the political spectrum, from disabled American veterans to Gun Owners of America, National Association of Manufacturers to the ACLU, Human Rights Campaign, and NAACP, all wrote to the court in support of strong protections of personal privacy. But a Supreme Court decision is not sufficient enough to stop these threats to nonprofits and their supporters. And by adopting this measure, Georgia, if I'm correct, would join 17 other states that have already acted to bring their privacy protections in line with constitutional protections recently affirmed in the U.S. Supreme Court. So for these reasons, we support this bill, which enshrines these constitutional protections into law and makes clear that Georgians are safe to support the nonprofits they care most about, whether the government agrees with those ideas or not. And if you have further questions, there's more details in that written testimony in your folders. Thank you.
Any questions by the committee? Seeing none, thank you.
All right, thank you.
Oh, wait a minute, one popped up.
One more. Hello.
Representative Stoner.
Thank you, Mr. Chairman. Can you give me a list of those states?
I believe the ones off the top of my head are our neighbors, Alabama as well as Tennessee are the most southern ones as well. But there should be others listed in that written testimony as well.
So I'm asking, so you don't know beyond just Alabama? I mean, is this California? Is this New York? Other states specifically besides just southern states?
So the ruling specifically, as I mentioned in the court case, addressed California, but as a southern regional person for AFP, we focus mainly on legislation that's been impacted in our southern states. So I mainly focus on Alabama and Tennessee.
Okay. Thank you.
That's all the questions.
Okay, thank you.
All right, that's all the speakers that we have, unless I've missed somebody. All right. Any discussion by the committee?
Move to pass.
All right, got a motion and a second. All those, well, let's see, before I do that. Okay, let me see who I got here. Who's 13? All right, Smith.
Thank you, Mr. Chairman. Thank you again, Mr. Pro Tem, for bringing this great bill. I would move that we amend by going to line 108 and striking not to exceed $10,000.
And put a period?
Yes, leave the period.
Okay. All right. Got a motion and a second on that. And let's see, let me go to Representative Evans.
Thank you, Mr. Chairman. And I'm not clear if my amendment would need to be in the same amendment as Chairman Smith, but in an abundance of caution, in case he wants to make it part of his, my proposal was at the end of line 111 to add the words beyond that subsection, between the word thereof and the period. Beyond this subsection, I'm sorry.
Is that an offer of an amendment to an amendment?
If he'll accept it.
Okay.
If you'll just repeat it one more time, Representative.
Sure. On line 111, but after the word therefore and before the period, add the words beyond this subsection. The purpose being to make clear that we are waiving sovereign immunity for purposes of the damages section that you're talking about.
I'll add that to my amendment.
Okay, thank you.
All right. So added. Yeah, I don't think we need a second. So added. Any other amendments? Any discussion on the amendment we have before us? Hearing none, all those in favor of this amendment, which includes line 108, putting a period after violation and striking not to exceed 10,000 and adding at the end of line 111 beyond this subsection, period. All those in favor say aye. Aye. Any opposed? All right, that amendment's on. Any further discussion about the bill? Hearing none, all those in favor of the bill say aye. Aye. Any opposed? Oh, we got one up. Okay, bill passes.
Thank you, Mr. Chairman. Thank you to the committee. I appreciate the good work put into this. Thank you
Yes,
very
sir.
much.
All right, if you're here for Senate Bill 542, it's been taken off the calendar. We won't be hearing that today. And I'm getting ready to lose some of the members I have here to go to another meeting. for lunch, and then, so what I'm gonna do is we're gonna break and then come back at 1 o'clock. Sorry.
You've been there, done that. I'm gonna eat, and then I'm gonna, let's do it. Hey, Stan, what's the next bill up after your 1 o'clock break? 433, okay. Okay, okay.
It's related.
Yeah, I was gonna say, didn't we just do that? Is 420 the one after that? See ya. See you then. Mr. Chairman. Well, they'll come back at 1 and they're gonna do another bill. I only have one. Let me just take a picture.
Well, here. Okay.
I've been waiting on you. All right, we'll get cranked up. We got a quorum here, so Senator Cowsert, you want to come up? I didn't see you sneak in. Go ahead and tell us about your bill.
We've already heard this one once.
And for those on
the
line,
donor
this is Senate
intent.
Bill 433.
Yes, 433. The idea from this bill is to create an enforcement mechanism for endowment agreements. And endowment agreements are written agreements between a donor and the institution receiving those, the donation for a specific purpose, and to allow you to have an additional mechanism to enforce that by going to court. There were a couple of changes that have been recommended and you have shared with me. One, there were some comments about the version that passed the Senate allowed for direct descendants to also enforce this. If I gave a donation and to establish the Cowsert Scholarship at the University of Georgia, and next thing you know, they stopped doing that. My estate is already closed out. This would allow a son or other lineal descendant to do that. Because it didn't specify in the Senate version how far down the line you would go, it's been suggested to me that we should use the phrase lineal descendant, which is a more legal term if you're in the estate planning world, and to define it only as a child or a grandchild. So this wouldn't extend for centuries, but the foreseeable future. I am fine with that change. The other suggested change was my definition of charitable organizations included 501c3s and 501c4s. And there was some conversation that since 501c4s are intended to be educational organizations more so than charitable delivery of services or whatever, and that they do have a component where they can support political causes, and sometimes do, more likely not specific candidates, but maybe promoting for or against a constitutional amendment or something like that. They are often engaged in it. It was asked if I was fine removing 501c4s, and I am, because I think it'd be nice to have those in case somebody did, but if that's an impediment on this bill passing, then I'm glad to just narrow it back down to other charitable institutions, and 501c3s are all, of course, tax-exempt charitable organizations. So I think that's the only two changes, but of course it's in the breast of your committee, and if you had other things.
The lineal descendants you have at lines 42, 43, and at line 66.
Right.
Is that where it'll go in both places?
Yeah, it added a definition, and then it put it in those two places.
Okay.
And the definition constrains it to a child or a grandchild.
All right. Now the other changes for your bill that I have listed here is on line 49, delete, quote, that donor's direct descendants. Is that part of this as well?
And I think we're substituting lineal descendants for that, I hope.
I didn't see, let's see, go back to donor's direct. Okay. If we change that to strike direct and insert lineal,
that would be suitable.
All right. And then line 55, add, in the event no legal representative was named by the donor's lineal descendants may bring a civil action.
Correct.
You want
And
that
that
in?
captures that, yes.
Okay.
Just clarifies what our bill was trying to do.
All right.
That's a real good example of a floor amendment in the Senate. You know, you guys don't experience those as often as we do. They are sometimes hard to do on the fly. I mean, Representative Oliver may remember some of those days, but that's one that somebody came up with the idea, hey, we need to make sure that a descendant can do it, and we put that in without doing lineal or filling in that blank. But that's, you're perfecting the bill.
When I first came down here and worked for Governor Harris, I used to listen to the chaos going on the House floor doing those amendments. It was kind of funny at times.
Yeah.
All right. Representative Oliver, you have a comment?
Does lineal descendants include folks down the line in addition to grandchildren?
It does not, because of the definition of lineal descendant limits it. We're putting in that in the definition section. It would otherwise, yes.
Okay.
But because for the purposes of this bill, it is defined only as a child or a grandchild.
And you feel confident, because I don't know the answer to this question, that the general rule that lineal descendants goes as far as their lineal descendants is not going to override this particular.
I feel very confident of that because the way we have constrained it by the definition.
Thank you.
Otherwise, it'd be like, you know, Genesis when they start listing everybody from, you know, Abraham on down to Jesus, literally.
Representative Crawford.
Thank you. Thank you, Senator, for bringing this bill. I'm looking at line 44 and 45 where it discusses federal or state law. I want to ask whether or not there is any inconsistencies with this language and anything under the Uniform Prudent Management of Institutional Funds Act under OCGA 4415-1. And if so, if we could, would you be open to a friendly amendment of just adding, in line 44, including OCGA 4515-1, just so we make sure that we are in compliance with that?
I am not aware of any contradictions in this bill. It is an expansion, though, because that bill allows the Attorney General to prosecute on behalf of any, I'll just say, jilted suitor that didn't get their wishes honored. This opens that up, which is part of the purpose of this bill. So I think you'd have to be careful how you worded that, not to essentially the exception swallowing the rule here. But my intention is not to interfere with any of the other provisions of that bill. And I used definitions to try to be consistent with it.
Okay.
Thank you.
Thank you.
Good catch. I mean, that was something we were very cognizant of as we were drafting. Also, the Charitable Corporations Code as well. We're trying to coordinate between the two so we don't undermine those in any way, but just expand them.
Thank
you.
Representative Evans.
Thank you, Mr. Chairman. Thank you, Senator. I missed the tail end of this bill discussion when we heard it last time, and so I apologize if this is a repeat. On the term or the phrase lineal descendants, I hear you that we're limiting it to children and grandchildren. And maybe it's an unpopular opinion, and that's the question. Did you feel like we needed to limit it that way? Otherwise, I'm having a hard time understanding the policy of we want to respect the donor, but only so long as their grandchildren live. And then after that, the schools do whatever they want to do, and there's nothing that can be done.
That was a compromise on my part.
Okay.
I did not offer that amendment, and it would suit me for it to go for more generations than that, because I think the intent ought to be, honored forever. But I think that's a reasonable compromise to give some certainty. It's almost just like statute of limitations on any other kind of civil action. I mean, how long is this remedy available? I would hope that you know the name of that law, but Representative, you
I was
just
about to say, is it a rule of perpetuities issue that we're
yeah.
worried about?
This runs
do we
that
even
off.
still have that in Georgia now?
I think we might have abolished it
We
a few years ago.
We abolished that.
If you want to amend this to extend it to yet another generation, that's fine with me. We had a discussion in our committee and on the Senate side that you might cap it at 100 years or something, and we rejected that notion. So that these would be enforceable as long as it was still in play. A lot of them you would imagine the money would get spent, and it would become a moot point eventually. But then some people made wonderful comments about donations of stock that end up, going up in a $100,000 donation ends up being $1 billion donation that you can't spend it all quick enough. So who knows? I mean, we could come up with a million permutations, but short answer after that long answer to your question is it would suit me fine if it went longer, but I think that's what was required to get the support for
Understood.
that. That helped eliminate some opposition from the charitable organizations that feared an indefinite statute of limitations.
Understood. And for your benefit and the committees, if they're interested, I have this amazing tool on Westlaw now that is AI-assisted research. And I asked AI if grandchildren includes great-grandchildren, and it largely does not. But the term lineal descendants is typically defined as children, grandchildren, or any further direct descendant. So we are limiting here if we do this.
This would.
In case
If
anybody
you want to add in great-grands, that's fine with me.
Yeah. Okay. Thank you.
Thank you.
That's all the questions I see.
All right.
No? Oh, all right. Representative Crawford.
Thank you. And again, Senator, I know we just discussed the OCGA 4415-1. Would you be open to including language in there on 44, amending it by just simply saying including OCGA 4415-1 so that we are explicit in that it's nothing in this language to contradict that act?
If you'd be careful how you worded that so that it doesn't exclude this, any differences to it, because there are some, but this was not intended to change the duties and obligations of people managing money. It just forces them to keep their word if they have a written agreement accepting a contribution with specifications as to how it's spent, and they agree to that. I don't think that's in that Uniform Act. I don't think that's really even addressed, other than generally you should be a good steward of the monies, et cetera. But that's my only hesitation. So I just want to be real careful how you don't just generically say anything contradictory in this you know, is void, because you might be voiding out most of the bill.
And I'm sorry,
I might not be articulating this or understanding either.
No, and I may not either. I guess the amendment that I'm looking at would be in line 44 to say by federal or state law, comma, including OCGA 4415-1. And that would be the only addition that I was speaking of.
I wish I was smart enough to be able to run through all the permutations of what that could mean, and I can't really do that on the fly without going back and reading that law to make, and then comparing with this to see if there are any other changes that this made. Conceptually, obviously, we wouldn't have put in the generic language, other federal or state law essentially includes this, so I wouldn't have done that if I thought that was going to create a problem. So it's just whatever this committee's wisdom would be.
Chairman Smith.
Thank you, Mr. Chairman. I'm the least of all the lawyers that serve in this house, so I'm just gonna try to think through this with y'all. With the inclusion there on line 44 or state law, would that not cover your concerns, Representative Crawford? I think that language and just the statutory interpretation of that phrase itself, just trying to think through this here with you, I would posit that would include your concerns and wouldn't necessitate including that code section within there.
I think you may be right. Thank you for that. Again, sometimes you just want to be as cautious as possible, but if that's something that may deviate from what it is that the senator is trying to do, I don't want to do that. So.
Sure. And I would just say, as far as in-field practice, and that's what I would argue, that provision would also encompass the code section that you wish to encompass, that it's already done so by the language there itself.
And if I can just respond very quickly, my understanding of the section is that that's how endowment funds are usually governed now. So I just wanted to include that language based upon, again, my understanding of how of the language that endowment funds and charitable organizations, they adhere to that particular section. So it's more so just to include language that's what charitable organizations are governed by currently.
Okay. Representative Oliver.
I'm listening to this discussion and thinking that you're right if it's all in compliance, but when there's a difference between 4415-1 and your bill, that's what will the court do? And I don't know enough to tell you that there is or is not a difference between those two this bill and that statute.
I think the Uniform Act would trump, given that it says in compliance with Georgia law. I think that those more specific provisions there would override.
I think that's a good answer, and I'm assuming you're right.
I hope so. We act like we know more than we do, and here sometimes don't tell the public watching at home.
Every day.
And we do have, of course, the ability to tweak and change things in the future if we get it wrong, which unfortunately we do on occasion.
All right. I see no other questions. What's the will of the committee? I got a motion and a second. Any discussion about amendments? Does everybody have the sheet in front of them?
Here, I got the, this way. So
Okay.
line 21.
So line 21, we delete or 501c4. Just take that out. Lines 42 to 43, add in quote, parentheses 8, and then lineal descendants means a donor's children and grandchildren. We would just add that in on 40. We're going 40. What happened up here?
No, that's that one that you just read.
Oh, that's just added on at the end. Okay. All right. So and then the next one is line 49. Yeah.
Just delete direct and add lineal.
Okay, got it. Okay, all right. Y'all are looking at it, and the one that we changed was on line 49, that section that said that donor's lineal descendants. We struck direct and put lineal in there. All right. Line 55 is going to add in the sentence, in the event no legal representative was named by the donor's lineal descendants may bring a civil action. And then on line 66, right after the word donor, insert comma, and the donor's lineal descendants, and then delete or. You keep the or?
Yeah.
All right, hang on, I hadn't looked at it. Oh, okay.
Yeah. That's just
That. All right. Representative Evans.
Thank you, Mr. Chairman. I wanted to propose a change to the proposed amendment on 42 to 43, but first I want to ask the senator if he thought adding the language that I said, which would be to define lineal descendant as a donor's, means a donor's children, comma, grandchildren, or any further direct descendants would kill the bill, because I don't want to do that. But from a policy standpoint, I think that's what it should say.
That's essentially the way it was drafted and introduced, but I think it might be a compromise just to say or great-grandchildren and leave it there.
Children, grandchildren, or great-grandchildren.
That I would consider that a friendly amendment.
All right, I would propose that, Mr. Chairman.
Okay. All right, well, as to the slate of amendments that I read to you, is any further discussion of that? Any other changes to that? Hearing none, are y'all willing to accept, or do I hear a motion on this slate of? All right. Any further discussion of that?
I'm sorry, Mr. Chairman, I came in late. Was the author agreeable?
I'm agreeable. Thank you.
Okay. All right. All those in favor of this slate of amendments, say aye. I'm sorry.
That includes the great-grandchildren addition that we did.
Correct. I think everybody,
I just wanted to
I
make
understood
sure.
it that
Okay,
way, but
gotcha.
I didn't say that, but thank you.
Okay.
All right. All right. All those in favor say aye. Aye. Any opposed? All right. Got the amendments on.
Thank
Any
you very
further
much.
discussion? Any other amendments? Hearing none, all those in favor of the bill say aye. Aye. Any opposed? Okay, we're done.
Thank you very much.
Thank you.
And I think Representative Kelly has agreed to carry the bill, right? Thank you.
All right. All right, that brings us to 420.
If needed. Here, you sir.
Wow. We got a distinguished panel here.
Team sport.
We roll big.
All right.
Thank you, Mr. Chairman. And just want to first say thank you for hearing this bill, taking up this bill today. So this is Senate Bill 420, and I know you have a substitute. Brock gave it to me and I already lost it. Hold on. Is it 44282-5S? Does that sound right? Okay.
That's what I have.
Thank you. And so before I dive in, I just want to thank a couple of folks. I did bring back up, I brought a great attorney and I brought a great farmer under the circumstances of this topic on National Agriculture Day in America. So I think this topic is very timely. And I do want to thank these gentlemen, our Commissioner of Agriculture, Tyler Harper, for his work on this over the last few months, and thank his staff who's here with us today. And also just thank those that in the industry, our farmers, also those in the real estate world who I know share concerns, and we've kind of bantered back and forth over language and what different meanings of words and things. I'm obviously the non-attorney in the group, but just realize that this is important to our farmers in Georgia. So I want to address a topic that's been garnering a lot of attention. It's basically the purchase of U.S. farmland by the investors in the CCP. Agriculture is the backbone of our nation, and the ownership of farmlands holds significant economic strategic importance. As we witness an increasing trend of foreign entities acquiring U.S. ag land, it's imperative that we examine the implications and take proactive measures to safeguard our interests. The purchase of U.S. farmland by foreign entities, in particular foreign adversaries, raises valid concerns about food security, rural economies, national sovereignty. Our farmland isn't merely a commodity that should be bought and sold, but it's the source of our nation's food supply and the livelihood of countless American farmers and rural communities across Georgia. While foreign investors, especially from countries with differing political, geopolitical interests, acquire large swaths of land, of farmland, it poses a risk to our food supply. I know myself, my colleagues, and our commissioner have talked about the national security concerns that we've seen. We've seen even recently with some of his Commissioner Harper's work in South Georgia. And it could lead to scenarios where crucial ag decisions are influenced by foreign adversaries rather than domestic priorities. Furthermore, it could result in increased food prices, which we've seen, and hinder our ability to respond effectively to ag crises. Moreover, just to close, and then we'll jump right into the bill, is the acquisition of U.S. farmland by foreign adversaries and entities have a detrimental effect on local economies. Family farms, which are the heart of rural America, may struggle to compete with foreign investors who keep deeper pockets and different profit motives than we've seen in so many of our small towns across the state. This could lead to a consolidation of land ownership, loss of jobs, decline in rural communities in terms of their prosperity. The national security implications associated with the ownership of U.S. farmland by foreign adversaries also creates a control over ag resources as critical as it relates to our national defense, which we've seen on many topics debated in the U.S. Congress currently, and particularly from those foreign adversarial nations that own significant portions of farmland, could compromise our ability to respond to emergencies or conflicts. We might strike a balance between the two, and we believe Senate Bill 420 jumps into that. So I'll just, I don't know, Senator Kauser, you have anything you want to add to that, or Senator Goodman, but that's kind of our premise of why we wanted to do this bill, is protect ag land, and I know there will be some more specific questions in terms of definitions and things that I'd like to thank Chairman Kauser for his work, working with a lot of the stakeholders who had concerns around this, and all his research and work and hours that he's put into this piece of legislation.
I would just make a couple of comments to keep it in focus. This applies only to agricultural land, not residential properties, and that's why we have specifically defined residential properties in the bill and made it clear that this bill would not in any way restrain the sale or transfer or acquisition of residential properties. And that is specifically, well, partly to make sure we don't violate the Federal Housing Act. But this bill is targeted at agricultural land. What we're really looking at is our nation's food supply. And there are a lot of discussions or rumors or whatever you want to call it going on about foreign nations that are adversaries of the United States acquiring enormous amounts of farmland that could actually impede our supply chain of food. This also applies to land within 10 miles of any military installation. I think we've or airports, military bases or airports, and that's a national security consideration. So we're looking at our nation's food security and our national security. The CFR that it references there, the United States Secretary of Commerce, has a list of foreign nations that are deemed our foreign adversaries or enemies. And right now it is my understanding there are 4 or 5 on there. It's China, Russia, Iran, I think North Korea, and I believe Venezuela is the last. These are all communist nations that have declared that they are enemies of America. So it's not something left in our discretion, and it's not targeted solely at China. That's the one most recently in the news. But that's what we're trying to do, is protect our food supply and our national security from foreign adversaries buying up property close enough to them to eavesdrop, to do spying, to actually control the distribution of our food products.
Yeah. And I'm not trying to be negative about the bill.
Yeah.
I like the bill, but is this a state concern?
Well, it's both state and national. The national government has the foreign adversary list, but they don't get down into state agricultural properties. I think they do have some requirements as to acquisitions near bases. This is more expansive than theirs.
And I would guess there's other states out there that have similar laws as this.
Yeah, that's a movement kind of almost nationally. I think a lot of people are advocates are concerned the federal government has not been restrictive enough. I mean, frankly, the whole China balloon thing, the spy balloon, got a lot of people's attention as what are we doing and how aggressive is that country in particular being, and do we have a national policy that's effective? If not, what can we do on the state level to sort of fill in the gaps?
Okay. Representative Kelly?
Thank you, Mr. Chairman. Isn't it true that that we've limited this restriction to just land closely held towards our military bases?
Two categories. Yes, within 10 miles of our military bases, but in addition, agricultural land anywhere in Georgia. But it can't be zoned for other purposes, and it can't be residential properties. We're talking about really farmland.
Thank you.
Okay. And Representative Silcox?
Yes, I was just curious, did we need a provision in here? Because I know the IRS requires, under the Foreign Investment in Real Property Tax Act, which the acronym is FIRPTA, F-I-R-P-T-A. It's an IRS form, income tax withholding, if there are foreign persons involved in U.S. property interest. So I was just curious if we needed to include that.
I don't see where it would be inconsistent if that's a federal requirement already.
Mm-hmm.
You know, if we do, I mean, I'm open to that.
Okay, thank you.
Okay. Representative Evans?
Thank you, Mr. Chairman. My question is on the definition of agricultural land on lines 12 through 15. I assume when you say that you are limiting this to just farmland, it does not include residential, you're relying on the language that starts but does not include on lines 14 to 15. Do I have that right?
You do have that right. But there's also another reference on line 46 and 47 when we define residential property, and then down on line 51 where it clearly states this subsection shall not apply to residential property. So that excludes the residential properties or properties that are zoned for things other than agricultural uses.
What if it's both? And I'm just trying to figure out if we might just need another word on line 15. But has that come up, and y'all had other discussions about this, perhaps across the hall?
It has gone through quite a few gyrations. The realtors fought this bill initially till we tried to appease all of their concerns. So I'm not quite sure. What would you change there on line 15?
I'm not sure yet. I was curious if it had come up with y'all. I'll think about it. But I do want to make clear, and I think I understand you to say you are not trying to scoop up residential property that might also be part of a farm.
Correct.
So if we were to add language to clarify that, you wouldn't have any problem with that.
I would not, but I wouldn't want you to make that so broad that if there's a farmhouse on a farm, that you exclude it. That's why we're trying to be careful. Now that, because, you know, most family farms, the family lives on the farm, so, but it is zoned agricultural. That's the use of the land.
But if it's also zoned residential, we've got to figure out when it applies and when it doesn't. And if we can't draw that line, and I'm now afraid we really can't, the courts are never going to let it stand.
So how would you propose to change it?
Well, I'm really, if you don't, it sounds like then the answer to my question is you do mean to scoop up property that can be used both as a farm and as residential. Because you said just because there's a house on the farmland, I don't want to exclude it. And so I'm trying to figure out, where do we draw the line? You can own the house, but you can't own the farm. Or we're getting into subdividing plots.
I'm not aware of any zoning scheme in America where agricultural land is prohibited to have people living on it. I mean, that's what you're basically saying, is that unless the zoning said this can only be used to farm and no human can live on it, then it's not farmland. And I don't want to go there. I can't think of a phrase to do it better than what we're doing. You know, that is, I get your concern.
Well, let me think on it. I wanted to just
Okay.
make sure I had your intent in it, and if I can summarize, you want to include any agricultural land, including agricultural land that someone may also use for residential purposes.
Right, for their primary residential purposes, not for rental properties or apartment buildings or whatever.
Okay, thank you.
You're welcome.
Representative Crawford.
Thank you, Mr. Chairman. I have maybe two questions just so I can better understand. If I'm looking at line 18, it suggests an agent of a foreign government. And so I have two questions. One, how do we determine whether someone is an agent of a foreign government? That's the first question. I don't understand how you make that determination. And I guess the second question is, who does that investigation, and how is that investigation conducted to determine whether someone is an agent of a foreign government?
Well, by agent, we mean somebody acting on behalf of a foreign government. We had this initially read a citizen of one of these countries, and the realtors raised sand, and they said that's going to create a potential discrimination against somebody's national origin. I don't agree with that, by the way. I'd rather have it apply to any citizen of those countries. Then you don't have to get to the point where you're trying to explain, are they acting on behalf of the Communist Party or not? But that was the compromise, to say that it would be somebody that's a non-U.S. citizen, they're not a legal resident here, and they're acting on behalf of one of these foreign adversaries. And I don't really, you're the very astute question that it's going to be definitional or interpreted essentially. I believe an agent is somebody acting on behalf of that foreign government.
And thank you. And if I may, the follow-up is, how do you investigate, or what would be the procedures to investigate whether or not someone is an agent? What would you do? What would be the procedures?
That's not specified in the bill. I'm not sure how that would be. You're looking now at burden of proof in a court case to enforce this, and I'm afraid that I'm not sure what all would be relevant or not to prove that. Some of these people are listed on our terror watch list or whatever, that, are known spies, so to speak, for other countries.
Is there not already a federal registry of agents of foreign countries?
I don't know the answer to that, Mr. Chairman. I know there are a list of, people on our terror watch list is what I hear it referred to as. I don't know how expansive that is. There very well may be.
Yeah, okay. Who's got 17? All right. Whitmer, Ted.
Mr. Chairman, thank you. Thanks for bringing the bill, and thanks for working through some of the concerns, particularly with the realtors. To the point or the question the representative raised, certainly if you are a citizen, are you an agent of the government, is it, in your opinion? Citizen of China, agent of the government?
I don't think that's a direct, automatic. I don't.
Okay. Well, I think that certainly if
if you're open to it, we can narrow this down back to a citizen. My thought is that you encapsulate citizen and those that are working on behalf of these governments. I think what the impetus of the bill is, and correct me if I'm wrong, Mr. Chairman, is that we're after bad actors here. We're not after someone that is in good faith buying a dwelling to live, work, play in the state of Georgia. We're after someone that, like in Pierce County, and that just happened right next to me, where 2 Chinese nationals purchased a piece of property, agricultural land, and had a highly technical and sophisticated marijuana growing operation that was supplying the Northeast, particularly New York, with marijuana. So we're after the bad guys here, and I think that the author has been abundantly helpful in trying to craft something that gets after those bad actors. So if it is the intent to try and narrow this thing so that it will, 1, withstand judicial scrutiny, and 2, get to the bad actors, I don't think the author would be opposed to doing that. What we're trying to do is navigate this, walk the tightrope, if you will, of trying to handle these folks that could be setting up grow operations, drug operations, or any other nefarious activity right near a military installation, and also take up valuable agricultural land. So I'm certainly open to, if the author is, narrowing this thing to a spot that that achieves that. I don't think anyone wants to destroy the American dream for any one of these folks that are coming in from these countries on this list that are actually after the American dream and not after Americans. That's the intent of the bill, as I understand it.
You
And
very accurately stated, and you notice right before where it says an agent says a legal resident. So if you're here and you're on a visa of any type, or you're a legal resident, or if you're a U.S. citizen, then you're exempt from this. 'Cause I don't want to go after the good actors, so to speak. And there are a lot of people from other countries that are here with our permission for great purposes. You know, I can think of all the students at the University of Georgia that are here furthering their education at our invitation and helping us. Got all kind of research projects with people from all types of different countries. We're only, you nailed it. I'm receptive to narrowing if this could be misconstrued as being people other than those with nefarious purposes.
And in practical practice, so let's just take, for instance, the case down there where 42 acres was purchased by 2 Chinese nationals. So the way that I would go about utilizing this law in the event that something like that happens is I would prove up the fact that these are agents of the Communist Chinese Party. And I would do that by bringing in evidence of, 1, where they're from, what they're doing here, and if they are on any of these watch lists, I suppose those will all be consequential when making that determination, and whether or not they're an agent of these listed countries. That's just some of the things that come to mind off the sort of top of my head. Thank you, Mr. Chairman.
Okay. Representative Oliver.
Thank you, Mr. Chair. I'm on the same wavelength as the whip here. It sounds like the burden is totally on the buyer to find out whether or not the purchaser is going to grow marijuana, to find out whether or not he or she has been physically absent or been a citizen of Germany or a citizen of, I mean, this is not limited to citizens of China. It looks like any person could be barred from buying property if they're, I guess, the agent of foreign government designated a foreign adversary might exclude this. But these lines 17 to 26 are a little confusing to me, and it sounds like the only enforcement mechanism is the buyer. And who's going to go after the buyer if he or she doesn't recognize that these Chinese folks, citizens coming in to grow marijuana,
Lines 75 to 78 set forth that cause of action. The legal counsel of any county, municipality, or consolidated government in which the land is located, the attorney general, or any person that was a party, that's not a non-resident, that was a party to the transaction, can file this action. To set aside, what you're doing is essentially voiding the real estate transfer to these foreign agents. So it's not,
the seller, the farmer, is going to be liable. He's a party.
he has no liability. The trigger for that is found line 67 to 70. A broker who is working for either the buyer or seller has to timely disclose to their clients the requirements of this bill. Be something that essentially at your real estate closing they would say, you may not come buy our agricultural land if you're acting as an agent for a foreign country.
And did the real estate lobby give you that language?
Oh, yeah, because it would have made it a crime for them beforehand. Yeah, they've written most of the bill indirectly. Almost totally gutted it, but not quite.
Is there still an economic development office in China for Georgia?
I think so. There at one point where I was the subcommittee chair on economic development appropriations, and we had 2 or maybe even 3 of them.
I think we
I
did
do
both
not
of them.
know if we still do or not.
What about Russia?
I don't think so, but I don't know.
I don't know either, but my historical knowledge is that we were very active. And of course, the trade with China is there any country we have a larger trade relationship with than China?
I don't know. I would imagine the European Union, but I'm not certain about that. But those economic development outposts were trying to encourage, Chinese businesses or foreign businesses to come locate in America.
Okay. Chairman Smith.
Thank you, Mr. Chairman. To my friend from Presbyterian College, fine secondary South Carolina higher education institution.
Secondary behind Furman, I take it?
They're at the bottom of the list there, Mr. Chairman. But I digress. The FERPA line of questioning, I understand what the gentlelady and my good friend Chairman Silcox's concerns are there, but would the Department of Agriculture even have the money to accept that data and process it? I mean, I think that may be a budgetary concern that I have, if you want to weigh in on that.
I don't think the Department of Agriculture has any role in this. I said Attorney General.
Attorney General, excuse me. Yep.
Yeah.
Okay.
I don't know what resources we give them.
Okay, so I just, that would be my only concern for the Attorney General, not Agriculture. Sorry, we've been dealing with farms.
You know what I would think would happen probably is somebody would complain. Somebody would say, these Russians are buying up all this farmland around me, and none of them can speak English. They're all, putting up listening devices and whatnot. And they would go to the county government and say, we got a problem with this. Y'all need to check these people out and see, are they acting as agents for a foreign country? Or go to the Attorney General. Right. Or else, one of the parties to the transactions could then say, I think I just got conned by, Communist Party of China or something. And then you would try to set aside that transaction would be your remedy.
Yes, sir. And then one other question, Mr. Chairman, if I may. They're in line 17 and 18. I'm just curious as to your interpretation there and what a suggested change, if need be, would be necessitated in that language. There's a comma right there on line 18, and I'm trying to see here about the proper interpretation of this statute as written. Does that not necessitate that individual you're trying to describe there, that they have to be an agent of a foreign government?
It does.
Okay. I just want to be clear, and I appreciate that.
It does.
Representative Kelly.
Thank you, Mr. Chairman. I'm again kind of those same lines, 17 through 20, and I got thinking if a foreign agent has been defined anywhere else in Georgia law or the U.S. code, and I looked up and found in 22 USC 611, we define, or the federal government defines, in the Foreign Agents Registration Act, they have a definition pretty extensive for what a foreign agent means. And I thought that maybe as we continue moving through testimony, maybe we could all look that up again. It's 22 USC 611, because it may be, as we move towards amendments, we may could just say, is an agent as defined by 22 USC 611, and that would define what a foreign agent is. And I think that can maybe provide the clarity we're sitting here talking about. Just something for us to consider as we move through the debate.
Representative Evans.
You said Evans. Thank you, Mr. Chairman. You mentioned, I think, Senator Calzert, that the remedy is to what? Well, let me ask a question, and then if the answer was included in something you said earlier, you can tell me. But my question is, what happens? Someone says somebody bought this property that wasn't supposed to. Where does it go? Does the property goes back to the seller, and then they've got the person's money plus they've got the property? Do they have to give the money back? Does something get transferred to the state? Like what happens?
Okay, the way I foresee this happening is at the time of the acquisition, the parties to the transaction are advised of this law, that it's improper and it actually violates our law for an agent of a foreign government to buy our agricultural land or land near a military installation.
Is that now something that'll be in all residential
That'll
contracts?
be a disclosure, just that stack of things. You sign an initial 50 pages. This will be one of those disclosures.
Who will be responsible for getting it in there?
Let me read again. It is on line 67 through 70. It puts that obligation on the broker to timely disclose to their said client the requirements and limitations of this code section.
Okay.
So they'll have to show you that at your closing, and that puts folks on notice, including the foreign agent, if they are buying land, that it can be that transaction may be voided, and it can be essentially set aside. This specifically blocks them from getting restitution for the purchase price. What I believe happens is you would simply void the transaction, and then the land is restored to the person that sold it. The owner.
Where is that? Where does it say it's void and that it goes back to the seller? It says it's void, but it doesn't. So what happens, though? Okay, it's void. Now what? Where's the land go?
That's the intention, that it revert back, but I'm looking to see where it says that.
Right. Then the seller's got to pay taxes again. Maybe they're dead. Maybe they've moved. How do we get it back to them, practically speaking? And then also, what if they're a knowing participant in this? They've had the disclosures too. So those are related questions.
I don't have the direct answer. I'm looking here.
It would go back to who set it aside, would it not?
That's what I think. It goes back to whoever. I think it reverts to the seller, but it's an interesting question. What if they were a knowing participant in this?
Chairman, I think Senator Goodman can talk a little bit on this, because some of this is, I think, covered in federal law.
I'm sorry. You'll have to get close to that if you can.
I can be loud, Mr. Chairman.
Yes, sir.
According to the Agriculture Foreign Investment Disclosure Act of 1978, the federal government already requires people from outside of our country to report. Now, I will tell you that it is not, we do not have a full view of what it is. report to the USDA. That's who they're supposed to report to. There was recently a Chinese national that we found out had 200,000 acres of land in Oregon. But in 2012, China had about 12,000 acres of land in the United States, and today it's about 400,000 acres of land. And I'll tell you, this is not a Democratic or Republican issue, it's an American issue. Sanford Bishop and Austin Scott, a Democrat and Republican congressman, both of them are great advocates for Georgia agriculture, put together a meeting in the field office in Atlanta, the FBI, and they gave us about a 2-hour briefing on China. And I came away from that really concerned, shocked in some ways of what's happening. When you look that China has new privacy laws where they can compel their citizens to give information. They can compel American citizens or American companies that are doing business there to give information. And it's estimated it's about a $600 million loss every year to our country with the data loss. And this is taken directly from Congress.
Well, to my friend,
Yes, ma'am.
you are my friend.
Of course.
But if we were in a deposition, I think I would say move to strike as non-responsive. Thank you. But it sounds like we're relying on federal law, but we're not writing it in our law. And so then why don't we just rely on federal law would be one question. Why not put that in here if that's what you're relying on to talk about what's going to happen when one of these transactions goes awry? If we need the state law, then we need the state law, and we don't need to be going back and forth between the two, in my opinion. And do you have a response to that?
In my research, and I'm not an attorney, but in my research, I believe it's delegated to the states in terms of land, farmland. So that would be my answer to that.
One last question, if I might, Mr. Chairman. On lines 56 to 61, this is the section that talks about if somebody who would be subject to this act gets a piece of property because of a debt collection or inheritance or something like that, they've got so long to essentially get rid of it, or they could be in violation of this. Can somebody please explain to me how that is not a taking or a contract clause violation?
I think it's giving them the opportunity to sell it. It's not taking it from them.
But what if they
It's letting
can't
them
sell
have
it? Or what if they have to sell it at a loss in order to keep from being in violation of this code section? How have we not deprived them of property?
Well, first of all, we're talking about people that are not United States citizens or here legally.
But we've said they can get it by operation of law if they had it in a contract or inheritance. So we're recognizing they have a right to it, but then we're saying you got to get rid of it. And I'm just trying to square those two things.
We're really saying they don't have a right to it, and if they end up it falling into their hands through inheritance or, like you're saying, a dispossessory or collection action or something like that, then they're on notice that they need to sell the land. They're not permitted to own agricultural land or land near military bases. These are agents of foreign adversaries that are not United States citizens and not here legally. I'm not sure what rights they have. Representative, may I bounce back to your last question?
Sure. Well, I guess I should ask the chairman if that's okay. I didn't mean to say.
Go right ahead. May I, Mr. Chairman? Okay. I think you're right, Representative Evans, when you raise what is the remedy. In this section on line 76 to 78, it is saying who has the right of a cause of action, but it doesn't specifically define that cause of action. I think you could perfect this bill by on line 78 where it says may file an action. After that include to void the sale or acquisition of the title and have that title revert to the seller or to the prior owner, however you want to word that. I think that's a really astute point you raised. I don't think it's as specific as it needs to be.
Thank you.
And that was our intent, by
Sure.
the way, is that it's not that somebody, get enriched by the thing, but it's to prevent foreign agents from buying up our farmland and holding on to it, or land near our military bases.
And this may be just an operation of how real estate transactions work. I don't practice in that area, but and I hear you and I appreciate that clarification. But let's play that out. So let's say I have a farm and I sell it because the upkeep is too much, the property taxes are too much. It's just it's taking too much time, and I'm trying to simplify my life and go sell bikes on an island somewhere. Then you come back and tell me it's mine again.
Okay, and that's what we're trying to do. You got a farm, you want to sell it, you can sell it to anybody you want to, but do not sell it to a foreign agent. And you're going to be told at the closing, if you do, this transaction may be voided. So yeah, I always wondered it initially in other states that are enacting these, well, why do the farmers want this? It's limiting the available market that they could sell to. Well, you got the farmer sitting next to me saying, we're Americans and we think it's the national security of this country and our food security is more important than our personal benefit of selling out to the highest seller. We will agree to be limited, that we can't sell to foreign agents from our adversaries, 5 countries in the world. And if we're placed on notice at the time we're trying to make that sale, it's hard to come back and complain later. Now, yes, it does limit who you may sell your property to, but it's a very specific universe you can't sell to. Only people that are acting as agents of a foreign adversary as defined by the federal government, and that is not a U.S. citizen or that's here as a resident alien. So you're right, that's what it does. It does limit, the freedom of transferability of farmland and land near military bases.
Has there been any, I don't know how long the federal law's been around or what other states have done, but you could see it going the other way too, where I played out a scenario where the seller gets it back and they didn't want it back. But what about a seller who does it to get the sales price and also get the property back, and then they get to sell it again? That it's a scheme on, like, I understand we've got a clear punishment, I think, now for the buyer. They've lost their money. But what about a seller who's not acting right?
I think it makes it a crime for a buyer or a seller if they intentionally, in line 79 to 81, an individual who intentionally violates the provisions of this code section, guilty of felony, fine not more than $15,000, imprisonment 1 to 2 years. I think that applies to sellers who are knowingly selling to, the Secretary General of the Communist Party of China after being placed on notice that that's illegal to do.
Well, $15,000 fine to get my property plus the chance to sell it again for multi-millions of dollars, I might take those odds.
If you're willing to spend the next 24 months in prison as well, maybe so.
Well, it's or.
I guess it's
15,000
no,
or.
or both. Last 2 words.
Yeah.
It's
doesn't have to be though.
No, doesn't.
Thank you.
Thank you, Mr. Chairman. I think the point that what happens to property after, if there is a voided sale, is a good point. I think the author has come up with a good amendment. I think it's unrealistic to think that there's farmers out there that are seeking out Chinese nationals to sell their property to enrich themselves. Got too much going on with the rain, planting, plowing, harvesting. That's not a real practical application of how these a transaction would work. And I'll just restate that this is a measure that is trying to address a national security concern and not trying to get after someone seeking out to better themselves in the United States. This is something we're trying to do to make sure that our enemies aren't moving next door to us. And it's like the author said, this is not a Democrat or Republican provision. This is just a provision to seek to keep Georgians safe, particularly those around military bases. And I'll also point out to you, it's 10 miles from a military base. The amount of property in the state is not going to be very significant, but it would keep those properties that are at our most secure areas, free from a possible enemy moving in next door, surveilling or doing whatever else they may do. If there's a amendment, let's make the amendment, because I think the lady is pointing out some good points here. Let's get it workable and move forward. I feel like we're just poking holes in it to see if we can kill it.
Mr. Chairman?
Yes, sir.
Do you mind giving me a few minutes?
Yes, sir.
I apologize to my friend if this is a deposition, but I just want you to understand where I'm coming from. And you know my heart, and I know yours, and I know we're both trying to do good work. But y'all, when we came away from that meeting that was put together by a Democrat and a Republican congressman, and I have in this congressional report, there are all kinds of quotes from Democratic congressmen and Republican congressmen about this issue and what we're facing. But in that meeting that we had, it showed some of these Bitcoin mining places that were put across the state of Georgia. And you look at where they're at, and you look at the proximity that they are to our military installations, you would have to be burying your head in the sand, not be walking away scratching your head. And then when we've got people that have ties to the Chinese Communist Party that are buying land next to an Air Force base in North Dakota where they do cutting-edge drone technology to put in a feed mill. So you know the law. I don't know the law like you do, but I know agriculture. And I'm going to tell you this. There ain't nothing about the feed business that's good enough to make me want to go 8,000 miles away from home to put in a feed mill, much less put it next to a major military installation where they're doing this cutting-edge drone technology. That's what we're trying to address. And what we've seen through our agriculture industry in terms of consolidation, we saw it in Georgia. When I was a kid growing up, Georgia was the 6th largest hog producing state in the nation in 1992. And then the integrators come about. Murphy, and Carroll, and Prestige, and Smithfield. And they got all of the production. You can't even probably find a hog farm in Georgia anymore, by the way. But they got all the production under their umbrella. And then Smithfield went about buying out the integrators one by one. And then Smithfield sells out to the Chinese. So now we're in a situation where Secretary Blinken is in Asia right now because of what's going on with the Philippines and what's going on with Taiwan and the things that China's trying to do. And we're living in a world where the Chinese are in control of 80% of the processing and marketing of pork in the United States. And so I would just say that that's what we're trying to address is our food security, but not only that, our national security. And with that, I'll quit giving my deposition, but I would say this. I wish that every member of the General Assembly could go and sit through the meeting that I sat through. And again, it was put together by a Democrat and a Republican congressman, and I came away with a sense of wow. That was the sense that I came away with, and that's what we're seeking to address.
Okay. Representative Holcomb.
Thank you. Thank you for the discussion. I have some questions. High level on the food security piece, and I hear you, what you're saying is the concern to be explicit that foreign adversaries would just take away the means of production and or the supply of food, and that's the domestic threat?
So here is a case right here, and if I could just read to you. The director of a Chinese conglomerate and 5 co-conspirators participated in the theft of inbred corn seeds from fields in the Midwest with the aim of transporting them to China. A U.S. company first notified the FBI of the suspicious activity during a routine liaison outreach meeting. Executives of the U.S. agriculture company estimated the theft would cause them 8 years of research and at least $30 million. The Chinese conglomerate involved in the threat and its seed developing company is a National Key Dragonhead Industries, a designation of the Chinese government bestows on private companies in several industrial fields in recognition of the significant role they play in promoting China's modernization. And it goes on from there. But yeah, it is a concern to me when the Premier of China has said that his stated goal is to destroy capitalism, and we see where we're at in Taiwan, we see what's happening in the Philippines, and the research that goes into these seeds can also be reverse engineered for nefarious purposes as well. And so on an a total level, yes, I'm concerned. You're living in a world today where you're not as food secure as your parents or your grandparents were. 67.11% of the world's ammonium nitrate comes from Russia and the Ukraine. Think about that. And then also, think about during COVID when we didn't have the medicines. We found out that we were so dependent upon so many of the raw materials for our medicines from China. Those same chemistry companies have ag divisions. And then you're talking about your plant protection products. And so if we didn't have the fungicides, herbicides, and insecticides that farmers need to be able to feed the American people, our yields would be 25% of what they are today. And consolidation, we have 4 corporations that control 85% of the corn seed market, 4 corporations that control 76% of the soybean seed market. We have 4 corporations today that control about 86% of our ag chem products. You have 4 corporations that process 85% of the beef in this country, and 2 of them are foreign owned. So when you take what consolidation is doing, when we, unfortunately, and I hope that changes. I had someone ask me when we were talking about this bill 2 years ago, they said 80 years ago China and Russia were our allies. And, you know, my grandfather fought right there with the Russians against, you know, Germany. And to my answer to that, I say, well, if in another 80 years, if China and Russia are allies again, we'll change the law. But yes, it is concerning, and I could go on a long dissertation, as my good friend would say, so I'm going to stop there. But
okay, yeah, what I'm trying to do is just to make sure that I understand the precise goals of what you're trying to achieve. And it sounds like the food security issue is just to ensure that there's a domestic capacity and also domestic availability of the product, correct? Okay. So I see you shaking heads.
That, and we do a lot of things in this building to protect farmland. We've lost 20% of our farmland in the state of Georgia since 1974. We average losing about 2,000 acres of farmland a day in the United States. And I just think that it is good policy as Georgians and as Americans to protect, because I will say this, can't anybody in this room go to China and buy farmland. Not one of us. You know what I'm saying?
Yeah.
And so I think that we also need to protect our rural communities and our agricultural production and our land from purchases with people that don't have our best interests at heart.
Okay. So that's one part of my question. The part with respect to the military bases, what's the national security issue there? Is it concern over surveillance? Is it concern about them just being adjacent? What is the precise concern?
In terms of myself, it would be surveillance. You know, I just can't imagine why anyone would come 8,000 miles away to buy 160 acres next to a military base in North Dakota to put in a feed mill where they're doing cutting-edge drone technology. You know, we have to ask ourselves what would happen if you and I went to China and wanted to buy 160 acres next to one of their major military installations.
Yeah, my brain doesn't think like that, nor does it think about North Dakota. I'm trying to focus on Georgia and what we're trying to do here. So I want to make sure that I understand it. As I understand it, and I have some background in national security, that the surveillance is currently illegal under espionage. So that's what I'm trying to really understand. And if it's a concern about them doing surveillance, I hear you. I think it's kind of unlikely, and candidly, they could just go to any restaurant near the post and they'll have people talking, and like you could do operational security just by that, because unfortunately people don't always keep everything concealed. But and 10 miles is probably outside the range. But with respect to specific questions in the bill, I'm looking at lines 21 through 26. Can you explain what those purposes are in terms of the absence? What are you trying to do there? One of them is absent from the United States, which I think that I understand, and then another one is absent from Georgia for more than 2 months. What's the purpose behind those?
My recollection, we were trying to capture foreign students here, allow them to purchase properties.
Okay. So they would be exempt?
You asked me, are they exempt? Yes.
Yeah.
It only applies to agents of foreign governments that have been absent from the United States more than 6 months out of the most recent 12. So if it's a kid that's here in college for 12 months and he's been here, then this would not apply to him.
Okay. All right. And then last question is, do we have any sense of how much land is currently owned, either farmland or near military bases, by those that would be covered by this bill? Do we have any understanding of what that currently is?
In the state of Georgia?
In the state of Georgia, that's all I care about.
I can tell you across the country.
No, sorry, for
in
Georgia?
the state of Georgia, no. In the state
We
of
don't know?
Georgia, I could not tell you that.
Okay. Do we know if there's any?
In my estimation, there is one farm that is leased, and we work in conjunction with the folks in the ag community. There is a lease farm that's owned by a multinational ag chem product corporation. They don't own the land; they lease it, and so we tried to leave provisions in there for that. It was a major one of the big four that sold out to a Chinese conglomerate because the fear was we have become so dependent upon so few sources for the products that we need to feed the American people that we did not want to do anything to disrupt that. They do research there, but it is not owned, it is leased.
So wait a minute, we're okay with the Chinese Communist Party leasing any property? We're just not okay with them owning it?
I'm not okay with either, but
That's what I thought you just said.
yeah, I'm not okay with either. This corporation leases the land, and
What corporation is that?
it's Syngenta.
Okay. And where's this land located?
I don't know. I've been told, but I can't remember.
Okay.
But we were trying to address that in terms of because we have become so reliant in our supply chain on these other countries. I do think that I think that the federal government needs to address these issues so that we're not. I don't think they need to allow these major corporations that are of strategic national security and for our food security to be sold. You don't have to be a genius to watch the news and see what's going on every day and geopolitically between the United States and China, right?
Yeah.
But my fear is that if we didn't allow some leeway with that farmers would not be able to have the products they need to feed the American people, and I don't think that's in the interest of anybody in the General Assembly.
Okay. I understand. Thank you.
Representative Kelly.
I was just trying, because I know it says we're prohibiting acquiring directly or indirectly any possessory interest. Does that not accomplish a lease as well as a purchase? So I think we don't approve of either of them leasing it or purchasing. I just wanted to make clear that was our interest here.
Yes.
Our interest about the interest.
Any other questions? All right, seeing none, we have a load of speakers on this, so I'll call y'all back up at the end.
Mr. Chairman, I have a bill in House Public Safety. I'm going to excuse myself. These gentlemen will be
Yes,
just
sir.
fine if that's all right with you.
Yes, sir. That's fine.
I'll be able to come back. I got a feeling this may take a little while.
We're gonna lose our attorney.
You boys are on your own. Good luck at the Shark Tank.
Hey, the whip money back home, can I give you a $5 thing? Get the conflict out.
So we give him billable hours.
Floor is yours.
Mr. Chairman, members of the committee, thank you. Jeff Ledford with Georgia Realtors, and we have had an interest in this for about the past 2 years, so I appreciate all the input we've been able to add to this. Our biggest concern has and continues to be the fair housing side of this. Fair housing goes back to, I think, question was asked about the federal laws. 1968, federal housing was passed. It covers national origin and applies to any residential property. With regard to, I believe Representative Evans, you had the question about the dwelling and what we're citing. That actually is the recitation of fair housing in the Georgia statute for dwelling. So that puts us in sync with fair housing by pointing to that. It also limits it only to the purchaser's dwelling. And that was very kind of thought out and specific language in defining what residential property means. So that if I were buying a small family farm and I intend to live there, I would not be precluded from purchasing that. However, by definition, I would then also not be someone who has been absent, and I would eventually meet that criteria. If I'm coming to reside in the United States, I would become a legal resident by virtue of doing that. And so I think it hits that. As far as agent, and I believe we've covered this as well, but the federal registry, the Foreign Agents Registry Act does cover that. That is probably the clearest list we can have. And then potentially you could have, if someone clearly is acting on behalf of, I think we had a question about someone installing cameras and spying. I think that would be a dead giveaway that you are potentially acting as an agent. But that removes, if we reference citizen, it then takes it to national origin. And fair housing, we have to be careful with because it doesn't just apply to those that are of the country I'm looking at, but also all those that are not. So if I ask you if you're from Cuba, I would be violating fair housing. If I assume you're not from Cuba, and I don't ask you, but I ask someone else, I'm violating fair housing. And we would also be looking at the disparate impact it could have on certain groups of people over others on how it affects them and their access to housing. So we do greatly appreciate all of you that have listened to us on this and worked with us, everybody at the Farm Bureau, to the authors of the various bills on this, because that is one of our biggest concerns.
I appreciate the work that y'all have put in on this and continue to do. I understand the concerns about what you can ask, and specifically, there's no prohibition of asking if you're a foreign agent.
Right. No,
okay.
That's not a protected class.
Okay. Thank you.
In fact, it actually, I think the reason that term we preferred, because it actually takes it beyond someone who is a citizen. I could be a citizen of a non-adversarial nation. I could be from Iceland working for the Cuban government, and I would be covered by this, whereas if we limit it to only the citizen of the adversarial, I would not.
Do you think by referencing the federal definition that I mentioned earlier, you think that would provide a little more clarity?
I think that provides excellent clarity.
Thank you.
Ms. Huskins, you want to say anything?
Sure. I'm Amy Huskins, and I have to say that I am not a lobbyist today. I'm not a lobbyist, period, and I'm not speaking on behalf of the State Bar of Georgia. I've appeared before you many times in that capacity, but I am not, and I'm also not speaking on behalf of my law firm clients. I was asked to speak, and I've spoken twice before on this topic this year in this beautiful building because I have some subject matter knowledge of the topic. And specifically, I'm going to focus on a very narrow portion of it, but a very important portion of it. And that is to do with lines 48 through 50. And this is where there is potentially a preemption issue that is front and center with all of us right now. And the part I'm focused on is not the agricultural land, but it says a non-resident alien shall not acquire any possessory interest in land that's of any kind within a 10-mile radius of any military base, military installation, or military airport. Here's the reason that's important. There is a federal agency, CFIUS. My law firm does a lot of work with CFIUS. It's the Committee on Foreign Investment in the U.S. It's been around, the laws creating it have been around since Harry Truman in 1950. When the Russians started creating the bomb. If we saw the movie Oppenheimer, you know what I'm talking about. And so it continues to this day. In fact, one of my law partners actually was a staffer for CFIUS. This is something that people spend their entire careers in Washington doing. And CFIUS is actually a committee. It literally is a group of people who meet. But it's a very special group of people. And the committee members are the Secretary of Treasury, Secretary of State, Defense, Homeland Security, Commerce, Energy, Attorney General. You get the picture. It's the people who run our country. Then they have full-time staffers. And so CFIUS they have many, many federal laws and federal regulations, and I want to focus on, like I said, this portion that talks about military properties. CFIUS has detailed regulations, and in fact, I've sent Representative Rees and Representative Gunner, there's hundreds and hundreds of pages of the detailed regulations on what is a definition of a military installation under the federal law. And that's where I think we're going to have a big preemption issue. And that is because the Georgia bill is not it doesn't define anything. It's just 10 miles from these 3 different types of things. But under the federal law, there are very detailed descriptions of the types of properties that the federal government is looking for vis-a-vis, is there some kind of threat to the national security of the United States from that particular piece of real estate. There are only 5 of those properties designated in Georgia. And it's a 1-mile radius, not a 10-mile radius or a 25-mile radius, it's 1. And let me just briefly tell you what they are. And I'll tell you why, as a commercial real estate lawyer, I'm speaking, because there's a big problem with me doing a real estate closing after this bill passes, when I have to choose, do I follow the federal law, do I follow the state law, which there's a state felony provision, which one do I do? And so, very generally, the current listed properties in the state of Georgia by the federal government, that they consider these so important to our national security that they're going to look very detailed information as to who can own property, lease property, have a possessory interest of whatever kind, and those are Fort Gordon, Fort Moore, Fort Stewart, Moody Air Force Base, and Kings Bay, the new naval submarine base. In addition, the federal law has a different group of real estate properties, and one of which they did mention. It's where the drone technology was in North Dakota, and that's a 99-mile radius. The federal government, CFIUS, they look for any type of real estate acquisition of any kind. None of those are in Georgia. 0. Thank God. We don't have anything in the state of Georgia that's so important. These would be missile silos, Area 51, I'm not joking. Things like that are so incredibly important. And for example, Dobbins Air Force Base is not anything I've read. So there are things that we think might meet this definition in the state bill that would not under the federal bill. So I call that to your attention, not as a national security expert of any kind, but as a real estate lawyer, because we still have in the current version of the bill, what do I do as a commercial real estate lawyer? Because thank goodness, thank you to everybody who's worked on this draft bill and the other bills throughout the session to narrow down the open issues. But we still have an open issue for commercial real estate, banking, underwriting, title companies, people like me. And that is, in line, bear with me, 29 through 43, there's still corporations, entities, companies that are not the individuals that we've narrowed down to be an agent. So the companies are still an open issue with me. If the company may have 26% ownership interest by somebody in Hong Kong, which China is now claiming Hong Kong is theirs, for example, is that something that I, as a commercial real estate lawyer, have to say, oh, do I hire a surveyor to do the Georgia 10-mile radius from any type of thing that is not defined here, military base, installation, et cetera, or do I look at the federal law, which is very defined? I know exactly.
Sorry to interrupt the speaker, but I'm at the table.
Second.
Okay.
Mr. Chairman, I ask for them not to be recognized for that motion. I'm not debating. He doesn't have to recognize you for that motion.
Right, and I will not recognize that motion. Go forward.
I'm sorry.
Go forward.
Okay. Thank you. I appreciate it. There is one new, I'm sorry. There's something brand new that just happened 10 days ago. And so under the federal laws, as I mentioned, they're very, very specific as the types of real estate that would apply to an investigation of foreign investment in those pieces of real estate. 10 days ago, President Biden signed a new law into effect. I think it was Saturday, 10 days ago, that allows a new party to come in and be a member of the committee, and that's the Secretary of Agriculture. Big deal. This is a major deal because now there will be, under the federal agency and the federal regulations, very detailed regulations into agricultural land for investment. It hasn't been the case so far. So if there's a preemption issue with the U.S. Constitution, there hasn't been with ag land so far. There will be. It hadn't happened yet, but there will be. And then further, there is, I think everybody knows this by now, but there is an injunction in the 11th Circuit that's, their final hearing is going to be in April, which is after y'all have to vote, on the Florida bill that's very, very similar to this bill. That was a full injunction. And the reason, the holding for the injunction was not equal protection or anything like that. It literally said, quote, in our view, the plaintiffs have shown a substantial likelihood of success on their claim that the Florida statutes are preempted by federal law, specifically, and then they mentioned the code section for CFIUS. So that's the law. I mean, that's our district. That's our jurisdiction right now. So will it be overturned by the U.S. Supreme Court? Who knows? But who knows? But I'm sorry? This is the 11th Circuit, right? So again, I appreciate you allowing me to speak, and we may have to come back next year and do a saving statute or something for anything that doesn't mesh with the federal law. Okay.
Okay. I don't see any other questions. Thank you.
Thank you.
Representative Evans.
May I be recognized for a motion to table at this point?
No.
Thank you.
All right. Let's see. Tom Fan.
Hello, thank you, Chairman and members of the committee. I appreciate the questions that you've had so far, and even the sponsors' willingness to make changes and their interest in national security and food security. I'm with Asian Americans Advancing Justice. We're a nonprofit organization that advocates for the civil rights of Asian Americans and immigrant populations in Georgia. We have concerns with this bill because we believe that it could exacerbate the discrimination against Asian Americans and other immigrant groups and would be detrimental to Georgia's economic interests. The definition of residential property, as Representative Evans pointed out, has been expanded to include dwellings for purchasers. It's unclear if, say, a non-resident alien could live in that land if it were also on agricultural land or land that's unzoned otherwise, which is prevalent throughout rural parts of Georgia, South Georgia. Because this issue remains unclear, it could be considered unconstitutionally vague, which could invite uncertainty, litigation, and lead to a chilling effect that would be bad for sellers and have a disparate impact on certain immigrant groups. Additionally, this bill could discourage investment in the state and global commerce with Georgia companies. It could decrease job opportunities, increase prices of goods for consumers. It would prevent small business owners from opening businesses throughout parts of states that's impacted by this bill. It's 10-mile radius outside of military installations, military bases, of which there are 10 in some of the most populated cities throughout Georgia: Augusta, Metro Atlanta, Savannah, Macon, Columbus, not to mention agricultural land. More generally, it's also unclear how this bill would improve or protect national security. Apart from sweeping generalities that echo red scare sentiments, what do these bills actually achieve for national security? I understand there's intent, which seem to be good. I understand there's a concern, but are these laws effective? And are there unintended consequences, such as those that could harm immigrant groups and harm business owners and the economy at large in Georgia? So with that, I appreciate the questions thus far. We still have a lot of concerns with this bill. We ask that, as is written right now, we ask that you vote no on SB 420. I would like to mention there is a very similar bill. If you have issues with this bill, there is SB 132 that passed in the House Agriculture Committee. It's in rules right now. If you have concerns for this bill, as it's written, there's one very similar to it in SB 132. Thank you.
Okay. I see no questions. Thank you. All right. Hillary Fentress. She's not here. She's not here. Megan Gordon.
This chair is much lower than I expected it to be. Good afternoon. Have we set a record for longest judiciary meeting yet?
Not.
No.
No.
Child's play. Minor league stuff.
What is the record? Has anyone? Well, now I'm just curious based on that like resounding. You know, I've said multiple times that you could never pay me enough to like actually hold elected office, and I really feel strongly in that opinion now that you've said that. God bless you all, and I don't mean that in the shady Southern way. Good afternoon, y'all. My name is Megan Gordon, and I'm the policy director at the Georgia chapter of the Council on American Islamic Relations. We go by CARE Georgia because that's a mouthful. And I want to discuss the very similar legislation out of Florida and how it sort of allows us to predict a future for Georgia. Real quick, I'm just going to outline the similar things it does for the sake of brevity. I'm going to oversimplify it a little bit. Florida's SB 264, which was passed last year, does the same core things as 420. It bans people, businesses, governments, and political parties from countries of foreign concern from owning any controlling interest in agricultural land and from directly or indirectly owning or having any controlling interest in any real property within 10 miles of a military installation. So a little different, but same core principles here. Aside from that, the bill also has restrictions specific to people, businesses, and the government of China. Despite the fact that they're already covered under countries of foreign concern, don't ask me about how Florida government made those decisions. I don't get it either. They're not allowed to acquire any real property in the state. So unsurprisingly, some people sued. The plaintiffs are all Chinese, but it's important to note that they're challenging that entire clause of the law, not just the China-specific provisions. They're alleging violations of equal protection because of the race, ethnicity, alienage, national origin provisions here, due process violations, saying that it's impermissibly vague because it's not entirely clear where the 10-mile exclusionary zone begins and ends. Do you draw a circle on a map that's not defined? So the legal question they ask, and of course the supremacy clause issue that fortunately someone much smarter than me about those federal issues already outlined for us. It's still relatively early days as far as litigation goes, so we've only reached the conclusions of a preliminary injunction. The district court denied it, but the 11th Circuit granted a partial preliminary injunction based on the likelihood of success on the supremacy clause claims. And I say partial because they only granted it to some of the plaintiffs, and that was just the 11th Circuit being conservative. They said in the ruling that all of the plaintiffs meet the criteria, but basically that a preliminary injunction is a privilege, not a right, so they granted it to some plaintiffs based on the urgency of harm to some of their pending real estate transactions. So that's why it's only a partial transaction. So all that to say, there are real legal questions here that are based on more or less the same statutory scheme and legal issues that are posed in this litigation. There's simply no way to write this that doesn't get into the supremacy clause issue. I'm not here to tell you that this is or is not unconstitutional. The district court, the 11th Circuit, they don't care about my opinion, and with all due respect, I don't know if they care about y'all's opinions either. So I don't really want to debate the merits of the lawsuit. The point I want to make is that it seems unwise to pass a law with legal questions that are already in litigation. Florida has essentially volunteered to go ahead and get answers. So the more prudent course of action would be to wait and see what those answers would be, especially given that the courts have agreed to an accelerated schedule of arguments here, so we'll get an answer in April. And then we can come back next year and see what the will of this body is. Now, I will say that really like your amendment suggestion. Care Georgia, our primary concern this entire time has been capturing innocent people in the scheme of the bill. I have no problem with the idea of stopping spies from buying agricultural land so they can hurt us, or from buying land next door to a military base so they can spy. I'm not here to lobby for spies, that would be a terrible idea for my career, in addition to being stupid. But I will say, but right now, I'm glad to see that foreign agent is in the bill, but without an actual definition. It's not really useful. I don't have to tell a group of lawyers the importance of definitions, right? Though I will raise one other concern, speaking of definitions and doing that really important tailoring work, is that if we look at line 33 and the clause that begins there, businesses domiciled in the U.S. with partial ownership, speaking of capturing innocent people in this scheme, that clause will capture innocent people who are simply trying to do business with their families back home. Let's say I'm a Russian American and my family back home wants to invest in my business. This would prohibit me from doing that, and so I would encourage some tailoring there. I'm going to be honest, I don't have a good idea that the sponsor wouldn't absolutely hate. So I have to pitch my concern to y'all smarter people than me and hope that the representative has another great idea. But those are my concerns and my suggestions for y'all, and I'm happy to answer questions if you have them.
Okay. Representative.
Thank you, Mr. Chairman. What line item in the bill do we specifically mention China?
Well, it's referenced in the foreign government of the get designated as a foreign adversary.
So we're only capturing China because our government considers them a foreign adversary to our country?
Yes, sir.
Okay, not just because we don't like the country of China. It's because the United States government considers them a foreign adversary. That's how they're captured?
Yes, sir, and it's the same in the Florida bill as well.
Thank you.
And if I can clarify, because the Florida bill had a double scheme in there, where they basically had something quite like this, and then additional, and China. So China was double mentioned in the bill. Correct, but the lawsuit is suing on both those provisions, which is why we have the same legal issues, because the supremacy clause issue is still here.
So last I checked, the injunction in Florida was as to two plaintiffs, but it wasn't for the entire bill. Is that correct? Or
Yes,
law?
sir. And the 11th Circuit did that simply because they were being conservative. They said that while all plaintiffs would meet the criteria, they said that it's a privilege, not a right. And so they granted it to those two because of the
Immediate harm.
irreparable harm it would do to their
Yeah.
pending transactions. Yes.
So it wasn't enjoined fully?
Correct.
Okay, thank you.
All right, that's all the questions I see. Thank you.
Thank y'all.
Julie Shavalkar. Hope I got that right. Good afternoon.
Good afternoon, everyone. My name is Julie Shavalkar, and I am here on behalf of Project South just to express our strong opposition to this bill. I think we find this bill problematic for a couple of different reasons. One, I know y'all have already touched on the agents piece, but we do think as it stands now, it's unconstitutionally vague, and we're additionally worried that due to the ambiguity, the bill could have a disparate impact on, anyone from East Asia, Middle Eastern, South American countries, basically immigrants in Georgia who are or who seem like they could be from one of the designated countries. They might be forced to prove that they meet the residency requirements just, because they might be from one of those countries. So we're concerned about that, and we're also concerned that the bill could have a chilling effect on individuals from those countries who might be worried that they would be forced to then prove that they're not an agent, and especially as it's not defined right now, how would they do that? They might want to avoid, questioning, so they may just avoid buying property or investing in Georgia altogether. Additionally, I think, again, it kind of depends on how the agent piece is interpreted or defined, but if it is expanded to citizen, then we're definitely still concerned about discrimination on the basis of national origin and alienage, which would violate the 14th Amendment. And then I know this has already been said before, so I won't go into detail, but we are very concerned about the risk of costly litigation because it does conflict with existing federal laws governing real estate transactions. As has been mentioned before, the 11th Circuit granted a partial preliminary injunction for a similar Florida law that restricted the purchase of land by certain immigrants, and this bill similarly supplants the carefully deliberated federal process for reviewing such real estate transactions that might have a national security, component or impact by instead instituting a restriction on the purchase and lease of property within a 10-mile radius of military installations, bases, and airports. So for these reasons, primarily, Project South is deeply concerned about the impact of this bill, and as it stands right now, we urge you to vote no. Thank you.
Thank you. She next. All right. Catherine Russell. Good afternoon.
Hi. Good afternoon. I'm Catherine Russell. I'm the Director of Policy with the Department of Agriculture, and I don't think I've ever spoken before this committee, so thank you for letting me be here.
There might be one or two others in here that haven't spoken before this committee. Yeah.
So anyway, thank you for having me. Obviously, the Department of Agriculture supports this bill. we have grave concerns about the industry of agriculture and the ability of us to feed, or for us to be able to feed our country, and to secure that. I had some thoughts about the bill, but I feel like we've been here a while, and I'm not entirely sure that I'm going to persuade anyone from their position. And so I'd like to kind of keep my, my points brief. A lot of the conversation that you've heard, I've been tracking and heard a lot of it before we got here. And it appears to me that there's a significant amount of conversation about preemption and about federal law, whether that be the Fair Housing Act or whether it be equal protection. And I think that everybody in this room pretty much knows how that works, and that if something's preempted, it's going to be preempted. And that's not necessarily, we can't undo that just by writing a state law. I know that there's been a significant amount of concern about the Fair Housing Act in particular, and I just kind of did a quick look when I was kind of going, you know what, I said I was going to keep my comments short, and so I'm going to do that. But I do think that everybody in this room is able to understand that, you know, not all protected classes apply in all acts, right? So I think that I could probably just tell you guys that this bill is about alienage, and that that's not a protected class with the Fair Housing Act and those concerns, and that nothing that we write in state law is going to override that, right? That's going to still stay in place. And I was just going to give you a quote from a Supreme Court case where they essentially recognized with employment, with equal employment opportunities, that national origin is different from alienage, and that if you are considering someone's alienage rather than their nation of origin for a purpose such as security and safety, that is acceptable. And anyway, if anyone's interested, I can go into it. But I'd like to just kind of lay that out there, and just to reiterate the fact that, you know, we are dedicated to supporting our farmers. We are seeing what's happening on the ground, and it's really scary. And I even though we've been in here for a long time, I don't think that we have given the subject the attention that it deserves. So, if there are questions.
Seeing none, thank you.
Okay, thank you.
Okay. Adam Bellflower. Brevity is your friend.
Yes, sir. Mr. Chairman, committee, thank you for allowing me to be here. There was a lot of talk about agricultural land, so being a representative of Georgia Farm Bureau, I just wanted to get up and voice our support for this piece of legislation, and commend all of the bill authors and the three gentlemen that were up here before me presenting this bill. So thank y'all for the discussion and the time y'all have put forth into this piece of legislation, and be happy to stand for any questions.
Y'all support the bill, right?
Yes, sir.
Okay.
Thank you.
Thank you. And Taylor Hawkins.
Thank you, Mr. Chairman. Taylor Hawkins with Frontline Policy Council. I imagine brevity is also my friend, so I will endeavor to be very brief. We do think this is a positive piece of legislation that sets in place common sense limitations in the interest of national security. We don't want to leave vulnerable through inaction our state's crucial military and agricultural infrastructure to those of adversarial intent. Just want to mention one brief fact. You did hear Senator Goodman mention this earlier, but I want to just re-emphasize it, that China has increased their holdings of extraterritorial agricultural land by over 1,000%. So while our national government recognizes that they are in fact a federal adversary, they're increasing that, and this legislation we believe is common sense in order to address a growing problem. And then the specific example of Grand Forks, North Dakota, just wanted to mention the letter sent by the U.S. Air Force stating the proposed project represents a significant threat to national security with both near and long-term risks of significant impacts to our operations in the area. So there's a statement from our DOD on what this type of legislation could correct. And then finally, Mr. Chairman, just wanted to mention, again, the bipartisan effort this has been across the country. The Washington Post noted as much in several of its headlines, recent articles discussing efforts like this moving forward across the country. And a final quote by Representative Abigail Spanberger, Democrat from Virginia, a former CIA officer, and one of the leaders of the House legislation that mirrors this at the federal level. She said, I think that our nation overall should be making really thoughtful decisions about the sorts of economic investments we see, and I want to make sure we're protecting American agriculture from our adversaries. I think this bill definitely ensures that we protect Georgia agriculture from America's adversaries as well, and we would urge you vote for this piece of legislation. Thank you, Mr. Chairman.
All right. I see no questions. Thank you. All right. Any further discussion by the committee? Do I hear a motion? Representative Kelly?
I was going to see if I could be recognized for a motion, Mr. Chairman.
All right, well, go ahead and make that motion.
Move to pass.
All right, have a motion do pass? Second. And a second. Any further discussion?
Amendments, Mr. Chairman.
Yes, sir.
I guess I could do these one by one, Mr. Chairman. First would be on line 18. After the word agent, I would insert as defined in 22 USC 611.
All right. All right, got a motion and a second? Which is that, you, 17? Or
he's got another motion.
okay.
Thank you, Mr. Chairman.
Another one later.
My amendment actually does not relate to the actual text in the bill, but it's to try to conform this with another code section, which is 1-11, that basically says aliens have all the same rights as citizens as long as the countries they're from are at peace. And so I think we would need to add to that code section 1-11 to the end of paragraph B, just the language, except as provided by code section 217, which is the one we're enacting.
What
here.
line are you on?
I'm not on a line. That's what I'm saying. There's a code section 1-11 in the Georgia Code. If I can find it. It says rights of aliens generally, and it says aliens who are subject to governments at peace with the United States and this state, as long as their governments remain at peace with the United States and this state, should be entitled to all the rights of citizens of other states who are temporarily in the state, and shall have the privilege of purchasing, holding, and conveying real estate in the state. And I think we just need to add to that, except as provided by code section 217.
That would be a whole nother section. Is that
It would
correct?
be, yes, sir.
Okay, and would it not also be the replacement of section 1 and moving section 1 into section 2?
In terms of the numbers, yeah, I guess with the convention of the Legislative Council, they usually do like to have the sections amended, have them in an order. So yes, sir, it would be replacing section 1 and then renumbering the existing sections as 2 and 3.
Are we going to take these amendments up individually, Mr. Chairman?
Yes, sir.
I would assume so.
All right, well, let's take up Representative Kelly's first, and then I'll come back to yours, and then I'll get to Chairman Smith over here. All right, any further discussion on Representative Kelly's amendment on line 18 after the word agent, the words as defined in 22 USC 611 be added in? Any questions on that? All those in favor of that say aye.
Aye.
Any opposed? All right, that's in. All right, and Chairman Leverett, I hope you've got that written down somewhere because I couldn't write that fast.
I've got it here, Mr. Chairman. And here.
Yeah. All right.
So I move another amendment, Mr. Chairman, in which we would add a new section 1 that would amend code section 1-2-11B, or paragraph B of code section 1-11, by adding to the end of that section, or the end of that paragraph, the words, except as provided by code section 2-1-7. And then we would renumber the existing sections as section 1 becomes section 2 and section 2 becomes section 3.
Okay. Anyone have a question about that?
It's simply to conform what we're doing here with another code section that addresses the same topic more broadly.
Right. Everybody understand it? Oh, that's, Representative Oliver?
I don't understand it. What is the code section and how does this serve the bill?
1211 addresses rights of aliens generally, purchase, holding, and conveying of realty. Paragraph A of that code section states aliens are the subjects of foreign governments who have not been naturalized under the laws of the United States. So it's paragraph A is a definition.
Georgia law?
Georgia law, 1211. Paragraph B, which is the paragraph I'm proposing to amend by adding language at the end, says aliens who are subjects of governments at peace with the United States and this state, as long as their governments remain at peace with the United States and this state, shall be entitled to all the rights of citizens of other states who are temporarily in this state, and this is the main reason for the amendment, shall have the privilege of purchasing, holding, and conveying real estate in this state. So I'm proposing that we add to the end of that paragraph the words, except as provided in by code section 2-1-7. Because we are enacting an exception to that general rule set out in 1211B.
217 then is creating new law, and we're amending the new law by your amendment. I'm following you now.
Yes, ma'am. I think so. We're creating 217 with the bill as it currently
Right.
exists. I'm just trying to make a conforming amendment to another statute, 1-2-11, that more broadly addresses the same topic. Because we are effectively enacting an exception to that provision in 1-2-11.
Mr. Chairman, I say with confidence that I've spent more hours at this table than anybody probably in the history of the world, but when I am this confused with the preemption of federal law and what federal law covers and what we are doing as we fly by here, I'm very concerned that we know what we're doing. It's frequently true that we don't know what I don't know what we're doing, but I'm relying on experts, and the experts here are giving me very conflicting information.
Well, I don't believe that the proposed amendment, while it may be a source of confusion, I can't speak to the lady's subjective state of mind, is not addressing the preemption issue. It's just simply trying to conform what we're doing here with an existing Georgia statute.
I'm happy to support your amendment. I don't know exactly what it accomplishes, but that's okay.
I second the amendment. All right, motion and a second. Representative Hong?
I think it's me, but I'll be after this.
Okay. Well, I had 16 lit up, so. Oh, okay, all right. Okay, motion and a second. Any further discussion? Seeing none, all those in favor say aye. Aye. Any opposed? No. All right, it passes. All right, and I believe Representative Kelly, I had you lit up.
There was some discussion earlier, Mr. Chairman, about what the strictness of the penalties would be for prohibiting it. I thought I heard some people voicing an opinion that they didn't feel it was strict enough. And so my amendment would be on line 80, strike the word or, insert the word and at the end of line 81, strike or both.
Everybody understand the amendment?
Yeah, and I'll get rid of the comma before or.
All right.
That'd be my motion.
I'll second.
All right, motion and a second. Any further discussion? All those in favor say aye.
Aye.
Any opposed? All right, Bill, that amendment passes. Now, what was that? That was, whose was that?
That was discussed earlier.
Oh. All right. Whit Burchett?
Thank you, Mr. Chairman. To the lady across the aisle, she had a interest in a possible amendment, as I understood it, to the remedy for when this is found that there is a void transaction. Did you want to offer that amendment?
I believe that Senator Cowsert, are you talking about on line 78?
Yes, ma'am.
I believe his suggestion was to add to void the sale, there might be a better term for it, to void the sale and have title revert to the prior owner. For the sake of clarity in the law, I don't mind moving that. But y'all, it may be of more benefit to you to move it.
Can we say to void the sale or transaction? Would that be better?
I think that's right.
Okay.
Maybe. Conveyance?
Conveyance, yeah. Because transaction would be a whole lot of other stuff.
Mhm.
Okay. I like that. All right. To void the conveyance. And have title revert to the previous owner. That'd be a windfall, anyway. All right. Did anybody want to make that a motion?
I'll move it.
And I have a second. All right. Any further discussion on that?
Just want to clarify, so as to avoid the conveyance and revert such property back to the seller, is that right?
It's to revert title.
Okay.
Yeah.
Probably the interest.
To seller.
Revert the
title to
interest,
seller.
not necessarily the title, but the. Right.
I don't have any strong preference on the words.
Okay.
I would just make sure that previous owner, that, Mr. Chair, that we discuss it, or if anybody has any input. Sounds like Chairman Jones may have input on. I want to make sure that we hear everybody out.
I've been channeling my input through Representative Evans. Yeah, I don't want to go on the record. Suddenly people will start thinking, wait.
He's actually participating in a judiciary meeting.
He's promised me if we do that for the rest of the session, I can channel through him, and so then y'all will support whatever he says, whatever I say.
Chairman Jones, you went to, which college was it you went to?
The University of Florida.
University of Florida. What was that you graduated with? In your post-secondary education?
Post-secondary?
Yeah.
My Bachelor's of Science in Finance.
Oh, after that.
I don't recall.
Well, yeah.
I'm having one of those Ronald Reagan moments.
Wasn't it a JD?
It could have been.
I second the amendment.
Okay. You got any more? Right. Okay. All right. Everybody understand the amendment? All right. All those in favor say aye. Aye. Any opposed? All right. We have that amendment on. Is that all the amendments? Hearing no more, I have a motion and a second on the floor. All those in favor say aye. Aye. Any opposed? No. Raise your hands, please. All those in favor. 1, 2. All right. And those opposed? Okay. 5. 9 to 5. All right. The bill passes. And that's our last bill. We're adjourned. I hope. No. 425 got sent back from rules. We're supposed to have another. Yeah, so we're going to